Yes.
Mayor, Your Lordship, I beg to mention item number 4. In this case, Your Lordship, the conducting council is from this Gauhati based.
Yes.
I beg to mention, Your Lordship, this item number 4. In this matter, the conducting council is from the Gauhati base. So he want to be physically present on this coming Thursday.
Okay.
Deeply obliged.
A prayer is made on behalf of Mr. B. Kaushik for an adjournment in the matter today on account of personal inconvenience. So, registry to list this matter again on Thursday, date to delivery. Thursday, huh? Yes.
My lord, item 22 to 25. These are appeals filed by the state, and the union also have filed an appeal. Their appeal is in the stage of delay condonation stage. So
We'll hear this.
that was the IA was also asked to directed to be taken along with this, but that has not been taken. I couldn't print the IA 122 of 26
Same judgment against it.
against the same judgment.
It's a common
The
judgment, my lord.
common
There was no
judgment.
award passed, and without passing the award, that is why we are before lordship.
My Lord Justice Silos.
Yes, my lord.
Yes.
It is stated at the bar by the learned counsel for the parties that an appeal has also been instituted against the impugned judgment involved in the present appeals, by the Union of India. So they said appeal is presently pending in the stage of condonation of delay. So the learned counsel for the parties have further submitted that there is already a direction in the said appeal for IA interlocutory application for listing of the same along with the present appeals. So accordingly, registry to list the present appeals along with IA number
122 of
122 of
26.
2026 on
Next Tuesday, my lord, then.
on date next Tuesday. Huh? 11.
My lord, and the submission would be from my learned friend, my lord, because I am not aware. I have not been served any copy.
Okay. Mr. Leonard
N. Ratan.
Additional Advocate General, कोई भी party ना लगे, हाँ? ठीक है sir.
Problem.
Deeply.
Your Lordship, I'd like to mention item 8, 9, and 10 on instruction of Mr. S. Dr. Senior Advocate.
Wait,
Lordship,
this matter has come back from Supreme Court.
I'm not aware of instruction. Your Lordship.
Now you don't permit us to dispose of the matters.
I think in this case, Mr. क्या नाम है उसका?
Yes,
Surajit
doctor.
will appear. S. Datta.
Yes.
Surajit Datta.
Yes. When will Mr. Doctor be able to
He'll
come?
be available on the 11th of August. That is Tuesday.
11th, we have fixed up many matters.
So many matters.
18.
I have this instruction only. Your Lordship,
Can't help it. A prayer is made on behalf of Mr. S. Dr. Leonard Senior Counsel for an adjournment in the matter on account of personal inconvenience. 8, 9, 10 day. Prayer accepted. A registry to list this matter again on 18, 8, 2026. The judgment is off. Judgment was off.
I'm sorry, Malak.
Judgment किसका है देखे तो judgment किसका है? Just see the judgment. Item number 8, 9, and 10. एक दिन से
Author of the judgment.
author of the judgment.
Yeah, I think judgment is passed by Justice Surana, if I correctly remember.
I also think it's Justice Surana's judgment.
This is Surana. Agent करेगा.
A listed in a bench where Justice Budi Habung is not there. देख के दे देना. Okay? No? Just check up and then give a date. Okay.
My lord, this is eviction matter, so this may be kindly taken up as unlisted after the listed items
Today
are
we are
proper.
rising at 1 p.m. What is the urgency?
My lord, this is eviction matter
Eviction from where?
from occupied land, my lord. Actually, my lord, I am for Adam Tadagis on the way, stuck in the traffic, my lord. The house is being demolished, my lord.
House is being demolished.
Yes, my lord. Very urgent.
Eviction, the eviction officer has passed an order.
Yes, my
Appeal.
in the single bench, my lord, the prayer was rejected, my lord.
Interim prayer was rejected.
Yes, interim prayer.
Okay, get it before 1.
Okay. Omelette.
My lord, I beg to mention item number 19 and 20 on behalf of N. Kumar for the petitioner.
Here we are doing nothing but only adjourning these matters.
Yes, my
AG is coming. Had you informed the AG that you are not? Forget us.
Yes,
Yeah,
yes.
we are glued here. But he has come for this matter. That
Yes,
much
sir.
courtesy was we informed. Okay. A prayer is made on behalf of Mr. N. Kumar. N. Kumar,
Yes, my lord.
Learned Counsel, for the petitioner for an adjournment in the matter on the ground of person inconvenience.
Yes.
For so, Mr. I. Chaudhary, Learned Advocate General, Arunachal Pradesh, is present. When, Mr. Chaudhary?
8th of September, if it is not.
As agreed to by the Learned Counsel for the parties, registry to list this matter again on 8/9/2026.
Obliged.
Obliged, my lord.
19/20 day.
Item number 1 and 2.
The matter is saying this one. Second to 2015
Your Lordship, may peruse the last order.
You are appearing for the
Petitioner matter in item number 1. Earlier, I was there, but due to some problem, I was discontinued. Again, the petitioner re-instructed me to continue the matter, my lord. So today I have filed my wakalatnama, my lord.
you are Mr. Taji.
Yes, my lord.
Although 1 and 2
Same.
are same, 2 is otherwise admitted. Only because the subject matter is same, both are tagged together. But in item number 1, the issue of maintainability was supposed to be heard.
Heard. This is with regard to that district-based enterprise.
Yes, my lord.
But Mr. Counsel, all said and done, this is not something which has been done by the state beyond its powers. If it is about 20 crores, again, everybody is brought in. So this is to give employment to a person's in a district. You are also in a particular district, you will also get it. And if it is about 20 crores, then it is put open. 20 crores is paltry these days. And secondly, if the person is not found, then the persons from other districts are also permitted. So the situations are envisaged. How is your right under 19(1)(g) affected here? How can it be held to be an unreasonable restriction?
So my lord, brief is not with the client. So have a next step so that we can have a fair hearing, my lord.
Next day, you don't come up and say that you are again removed. We will impose heavy cost on the petitioner. Who is for the other writ petitioner?
I'm for item number 2.
You argue.
Your Lordship, our case is already admitted. Only
Admitted?
final.
What admission? We can take it up for final disposal.
For it, Your Lordship, I pray that the conducting counsel, he may be allowed to appear before this honorable court.
We did not prevent him, did we? Did I issue an order that he should not come? Item number 1 of Lekha. Mr. Neelam Taji, Learned Counsel, has submitted that although earlier the brief was taken away from him by the petitioner, however, on a request made by the petitioner again, he has submitted a wakalatnama in the matter again. He has submitted a wakalatnama in the matter today. Accordingly, he prays that the matter be taken up on.
Let it also be on 8th, my lord, if it is
On
not in there.
8/9/2026, along with WPC number 136/2021. Yes.
Item number 3.
Classification to domicile or
Yes, Mr. Modi.
Marvelous. My lord, before come to the facts of the case, or as per the order dated 5/5/2026, my lord, there was an instruction from this honorable court
Five?
to produce that whether the,
Five?
my lord, this is 5/5/2026. And there was an instruction that the claim of the respondent is that they have already get the payment. Therefore, there was an instruction whether the payment has
First
made
and
or not.
foremost, Mr. Modi, what is this case about?
My lord. In fact, this case has been prepared, my lord, against the order passed by
You
the
say that
single
the
judge.
land 46 something that is there, you don't have a land there.
My lord.
And the learned single judge, honorable single judge has
My contention,
details gone into the issue.
my lord,
What is the error there in that judgment?
I am ready to demonstrate, man.
Then okay, demonstrate.
My Lordship, leading counsel, Mr. Senior Counsel Titi Tara is stuck in traffic, Lordship. This may be pass over for time being, Lordship.
Findings of the 13.
Page 1.
Lost the place.
Page 334.
334. Para 13. Kishore.
Yes, total.
You're totally disputed questions of fact. Totally disputed questions of fact. You have given up your right in the title suit. And now you had around 7 acres found by them. That 7 acres also you sold out. Now again you come back and make a claim.
My lord. It's, my lord, exactly, my lord, it appears seems so, but that is not the case. In fact, my lord, that what the land has been sold are the different cases.
Be here. We'll take it up.
All right.
Item number 5.
My lord, interim orders are passed, we understand, on the satisfaction of prima facie case, and the law flowing from it is settled. But what happens in a situation where the facts prima facie are totally against the petitioner, and the law flowing from those facts is also
71.
settled? Precisely. Page 71 says it all. And what is the law, my lord, governing the field? The law governing the field is equally settled. Then, my lord, I ask myself, can we say that the prima facie facts are in favor of the petitioner?
Mr. Tiwari, this is a issue. Anyway, right, wrong, there is a interim direction. We'll examine that. There is no issue.
My lord, I understand.
But we don't want to examine it in absence of the.
Yes, it cannot be. It cannot be.
You get it served by way of Dusty. Give me a date. We'll fix it. We'll also make the interim order returnable. On that day, we will.
My lord, whether my lord will give me 5 minutes, I'll just find out if it can be done so that matter can be taken up because I'm here for a couple of days.
Then
So-
Thursday, we can take up this matter.
Very well, my lord, I have to find out. My lord, I'll just give them the date, my lord. I'll tell them.
No, give us so that we can incorporate that.
Is it possible? Is that by this week? Possible.
Yes, my lord, we'll do it today itself. Today?
No. Can you?
Yes, sir.
We have time till next week. There is no issue. You, if you can do it, because only one day is there tomorrow.
My lord, it can be taken up next week.
Tuesday.
Today it's
Tuesday.
Next Tuesday.
Next Tuesday.
Very well.
But Mr. P.K. Tiwari, learned senior counsel, assisted by Mr.
El Tara.
Huh?
Tara, El Tara.
L.
Tara.
L. Tara, learned counsel for the petitioner. Also heard Mr. N. Ratan, learned additional advocate general, appearing for the state respondents. The present intercourt appeal has been so instituted, assailing an order, assailing the interim directions passed wide order dated 23/6/2026 in WPC number 279/2026. Also, considering the nature of the issue arising in the present writ appeal, this court, we are of the considered view that a notice, that before proceeding to consider the prayer made in the present appeal, a notice upon the respondent number 1 is to be effected. Service of notice upon the respondent number 1 is to be effected. The learned counsel for the petitioner has submitted that he would effect the service of notice upon the respondent number 1 by way of dusting mode. First of all, issue notice returnable 11/8/2026. Mr. Ratan, who is assisting you? Ms. Y. Pasa, learned government advocate, junior government advocate. Junior government advocate accepts notice on behalf of respondent number 2, 3, member secretary, Gram Panchayat?
Yes, my lord.
4. 2, 3, and 4. No formal notice. Petitioner to serve notice upon the respondent number 1 by way of dusty mode, routed through the registry of this court.
Appellant. Petitioner would be replaced by appellant.
Appellant. Appellant. What is it? Learned counsel for the appellant. Appellant. Routed through the registry of this court. Steps, such service be effected on or before 7/8/2026. Issue notice on the prayer for interim relief, also returnable on 11/8/2026. It is made clear that on the next date of listing, this court would consider the interim prayer made in the present writ appeal. Also, registry to list this matter again on 11/8/2026.
Item number 6.
It will writ appeal or writ appeal.
May I please, my lord? Well, here, the petitioner, my lord,
Where are you now, Mr. Segar?
my lord, I have been released, my lord.
You have been released.
Released, my lord. My lord. Next.
माथा दर्द होगा देखा ही नहीं परीक्षा
You will also project that the earlier, the single judge
Yes, ma'am.
had drawn a conclusion to the effect that the AFS, the Assistant Conservator of Forest, ACF,
Professor,
cannot
sir.
be put as a DCF.
Yes, ma'am.
Although tentative, there was a conclusion. We'll examine it, but no stay. You join, it will be outcome of this case. You are a,
My lord,
You are a member required in this time in the forest, not in the courts. We'll see if something can be done, we'll do. Because this is one issue which would require some consideration, whether an entry cadre officer can be posted against a cadre post. And one thing,
Yes, madam.
this post is an IFS cadre post.
IFS cadre, my
So how are you all having any right to hold that post?
Because, my lord.
This is an cadre post.
Yes, cadre post. My lord. Because, my lord, I am also a DCF, my lord.
You may be a DCF,
Yes,
but
my
you're not an IFS.
Yes, my lord. But my lord, he is a provisional, my lord. In the schedule of the post, my lord, it is to be made by an officer who is should be a senior officer.
Where do I get it?
Attached officer, my
Where
lord.
do I get it?
My lord, kindly see the my lord, rules, my lord, for a moment, my lord.
Where do I get it?
My lord, page 176, my lord, and is the rule, my lord.
176.
My lord.
172.
And my lord, the schedule of the post, my lord, kindly for a moment, my lord. Page 184, my lord.
Schedule of the post.
Page 184, my lord. These are the my lord, posts, my lord, who will be holding this post, my lord. First, my lord, category A, my lord. Post under.
DCF is you are a selection grade officer.
Yes, my lord. And selection grade officer is a DCF, my lord. And my lord, we are concerned with the my lord, page 185, C category C, my lord, of the schedule, my lord. May I read, my lord? Post under additional deputy commissioner, deputy conservator of forest as attached officer in various forest divisions, my lord. Here it is not said that, my lord, who will be the, my lord, the forest DFO, my lord, forest divisional officer, my lord. But, my lord, in a forest divisional office, my lord, there has to be an attached officer, my lord, who will assist the DFO, my lord, at serial number 1, my lord.
Okay, if we find that because in terms of the earlier order,
my lord,
there is a finding.
My lord, because, my lord, the attached officer is to be a, my lord, in the rank of additional deputy conservator of
Para 19, page 168. Para 19 or 100.
my lord.
Yes, Mr. Ramon.
My lord, before, my lord, just one thing, my lord. As a attached officer, there is already.
Okay, we'll see. We'll remove him from there. Don't worry. But you going back maybe.
Your lordship has seen, my lord, these rules. My lord, this.
See, you don't have an IFS officer to post there now.
Right now, my lord.
You don't have. So you will have to hold it by an AFS officer.
My lord, yes.
That's your predicament. You can't do anything.
My lord.
Now, if the SCF is not entitled to draw that post, hold that post, may be wrong. What we are saying may be wrong. We'll examine that. But there is a categorical finding in page 168, para 19, that he was not, the private respondent was not eligible to hold that post. So if that finding is there, so that finding presently has not been considered, right? So we'll have to examine this issue.
That finding, my lord, in Himutaba or other cases, my lord, that was, my lord, perhaps, my lord, deviated, that the cadre post can be replaced by only the same cadre post, my lord. My lord, that was changed. Now here, madam, when you see
In
the
I
rules,
don't know, I have not seen the rules. In IAS, IFS, there is a provision called 9.2 in the pay rules.
my lord,
Just a declaration that he is eligible to hold that post is enough.
my lord.
A chief secretary can be bought and made to sit in a administrative tribunal. Royapa and all those cases are there.
Well, if the applicant can demonstrate before your lordship, the private respondent, my lord, is not
Today we are
qualified,
not. We are not.
qualified to manage
Today we are not. Today we are not for any demonstration.
In rules
We'll
also,
keep
my
that
lord, there is any
demonstration.
embargo, my lord.
You serve the private respondent.
Oh,
you are appearing?
Yes.
Okay, when? Tell me, give me a date.
And next Tuesday, my lord.
I would
Tuesday we
have
are fixed.
preferred
Thursday.
I would have preferred day after tomorrow, but
Mr. Soike is preoccupied.
Oh,
No,
no,
no, I will
Mr.
be-
Soike is
no,
too
no.
busy. Thursday, next Thursday.
Next Thursday, my lord.
Next Thursday.
Of the record, can I make just a small submission?
Yeah.
Rather, it's a request to my brother, my lord. Now, my lord, I don't know how it's correct, but source confirms that, my lord, the appellant, my lord, is, my lord, making some social media commentary, even the, my lord, video recording of the court proceedings and commenting, my lord. My lord,
Get it to us,
my lord,
get
I
it
just
to
request
us.
Mr. Said,
Oh, we are waiting for
request is-
something like that. We are
request is
waiting for
declined
something like that.
from doing all these things, my lord.
If
Well,
there
I
is
have-
something in your hand,
I
get
have
it
lot
to
of
us.
things
We will do what is required.
Well, I can only request Mr.
Now he is
Said,
come
my lord,
to, now he
advice
is,
is inclined to refrain
now
from
he
doing
is
all
come
these
to
things, my lord.
Itanagar.
My lord.
We will try to put him at more comfortable places. Don't worry.
My lord, next Thursday.
Heard Mr. Saikya, Learned Counsel for the R. Saikya, Learned Senior Counsel, assisted by Mr. L. Bam, Learned Counsel for the petitioner. Also heard Mr. R.H. Nabam, Learned Additional Advocate General, appearing for the state respondents, and Ms. N. Dungan, Learned Counsel, appearing for the respondent number 3. Also, as agreed to by the Learned Counsel for the parties, registry to list this matter again on
11, I think, my lord, Thursday.
no, 13/8/2026 for admission.
Obliged.
Obliged, ma'am.
And show your bona fide, join back, we'll take care.
Yes, sir.
Item number 7.
Your Lordship will recall this is.
The moment I saw the case,
Yes.
I had a back pain.
Yes. Your Lordship will also recall on the first day, your Lordship had directed
Yes.
state authorities.
Mr. Ratan, this is not done.
My Lord, may I point out a few things, man? In the meantime, they have terminated the contract. Your Lordship may kindly have the last order for
No,
it.
the report, what happened after that?
The report is in the additional affidavit, my Lord.
They have filed an additional.
Yes, it starts, it was filed yesterday, 974 onwards. The estimate they have sent and how the chief engineer MRT has responded is 987. This is a list of defects in their proposal. The long list, when I am not bothered Lordship with that, your Lordship may kindly have page 988. 2.24, Roman 4, small 4. 2.2, Roman 4, small 4, Roman 4. 988. Yes, my Lord, got it. Cost estimate for remedial measures and structural strengthening of flyover piers, estimate of rupees 6.08 crore has been proposed in a proposal, whereas details given in Annexure 4 was for an amount of rupees such and such crore only against the proposed remedial measures and strengthening of piers on the basis of report submitted by the quality auditor and rectification recommended by IIT Patna. In this connection, it is not clear how the defective items of works were accepted by authorities engineer and recommended for payment, and whether any recoveries have been made from the original contractor for the work. Accordingly, authorities engineer is to be so cost for defective works, and action against original contractor for recovery of cost of defective works may be initiated. This is the state we are in. The estimate is highly inaccurate.
Who had submitted this estimate?
The department. Highways.
Somebody had come here also last day.
Yes.
Yes, Mr. Ratan, what is this? Seems that you are not interested to get this work completed.
My Lord, my instruction or as per the status report, these are observation by the MORT for the revised cost, my Lord.
No, you come to 2.1.
They returned it.
You come to 2.1.
To resubmit.
No, resubmit means this is just a bogus submission, it seems. I'm sorry I'm using that word, but it seems that just to submit something you have submitted without any application of mind.
Exactly.
If you're not in a position to do this work, kindly declare before this court that you are not in a position to do this work. We will have it done by some other agency.
My Lord,
because we are concerned with the citizens.
No, my Lord, again.
This is not the way, Mr. Ratan, we will.
Yes, my Lord. In our
unfortunately, this did not come to my notice yesterday night because I got the files too late.
Yes.
Was going through, I could not. I was thinking that no affidavit has been filed.
Your Lordship will recall the first day your Lordship had directed that the road be maintained to such an extent.
I'm coming to that. I'm coming to that. And Mr. Ratan, now it is not the citizen, it is the judge of this court who is getting an injury going through that road.
Of course, my Lord. Now, if my lord comes to our report, my lord, at page 970.
40, I don't want. What have you done? Who is doing this?
This, my lord, will kindly see page 977. This was with certain observation, it was written by the mort. So accordingly, further expeditious comprehensive review and compliance in accordance with the observation raised by RO, Itanagar mort, have been completed, and the corrected, updated, fresh, revised post, balance post, including additional scope, further supported by detailed quantity calculations, revised BOQ, engineering assessments, approved drawing structural.
Where are you reading?
Page 977.
No, what is the date of that?
977.
This is the paragraph content.
This is the paragraph. After the return of this by the mort, what our engineer has done is that he says that all comprehensive review has been done, my lord, and it is ready for resubmission, my lord.
No, that will take more than a month now.
No, my lord. This was the return back on 27th of July. Now, these are calculations have to, with this observation, what the observation made by the mort has to be rectified, and this has to be resubmitted. Now,
okay,
this we have done, my lord.
What we do is,
And
this has been resubmitted?
No, my lord. No. It is.
When are you going to resubmit it?
It will be resubmitted.
No, when?
My lord.
Tomorrow?
To that, I'll have to take.
Get your instructions. Tomorrow we'll have this matter on. We'll have this matter on Tuesday. We are not going to delay this. We'll have it on Tuesday. Mr. Kato will have instructions. You are appearing for the mort. We'll have instructions whether a preliminary assessment of the revised proposal satisfies the queries and the objections raised. Then we will ask them to proceed. We'll not keep this pending. Because if you have not given it, Mr. Ratan, your chief engineer and all will be here, and we will hold that they have failed to do this work. It's, I think, high tech.
My lord, in fact, if lordship permits, what the MRT has said while returning the says the High Court has already issued instruction for expeditious approval due to under the circumstances submission of such estimate
without due care.
It is not appreciable.
I've seen it.
My lord. My lord, I'll take instruction with, when they are going to submit. My lord.
Not going to submit. Submit in the manner that an engineer will do.
Yes.
It seems that you're not using your engineering skills.
Within 2 minutes. Instruction.
And Mr. Ratan also take an instruction. Why the road is not motorable?
Yes.
There is already
there
is already an direction from this court.
Yes, my lord.
It's not motorable. I've been coming through that road. It's not motorable on either sides. It's not there. Pedestrians as well as motorists are facing a lot of problems.
Yes, my lord. My lord.
Now, why it is done? Who is responsible?
My lord.
We'll draw up contempt proceedings.
My lord, there was a tender floated for.
We don't know what tender. We don't know. Ask your chief engineer to be there on the road. It is his duty. He will have to get it rectified by weekend.
My lord, since last night the work has started, my lord. Since last night.
This happened lots of times.
Since last night, because the short-term maintenance contract tender has been finalized, and
we don't know. Ask your engineer, executive engineer, assistant engineer to be there on the road by Monday when I come. If I don't find that road to be in a motorable condition, I'm getting this matter anyway listed on Tuesday. I'm going to drop serious proceedings here. This is not the way you treat citizens.
Yes,
you're putting everybody into life into jeopardy.
My lord,
who is going to bear the cost?
My lord, of course, my lord. That's why there was delay in even the final.
Nobody is care. Nobody wants. No care. Nothing. Why is the engineer there? Why is the executive engineer there? Why is the chief engineer there? Just to sign files.
They are also trying. They also tried to.
We don't know. If they want, they will go to the field and they'll stand there and get the works done.
My lord,
shall I put it on record?
My lord, by next Tuesday, my lord will.
No, I want it by Friday. Saturday, I'm coming again. I'll move around this time.
Yes, my lord. My lord will find, of course, differences. My lord,
not differences. I want a totally motorable road on both sides, as it was done after the first order.
Yes, my lord, that.
It's not for me, it's for the citizens.
Yes.
And that is a real congested area.
Yes.
Then And I don't know what is happening beyond that, beyond Hatimata, that side.
My lord, if I can use the word, it's a total mess.
Mess. Last time when I was here, it's around a year back, it was like going in a boat.
Yes.
In my Innova car.
Yes, my lord.
Mr. Ratan, this is not taken.
Yes, my lord. Only last.
Both things you give me before 1 o'clock. We'll take it up before 1 o'clock, call this
Yes,
matter. And or we'll again list this matter on Thursday. We'll ask all your officers to be here. We'll test them. We'll see what they are planning.
My lord, before 1, I'll.
Before 1 you give me. Mr. Yes. Come back at once. And I'm not taking this lightly, Mr.
Yes, yes.
Item number 11.
May I please, Your Honor? So this is a very sensitive case, my lord. This is pertaining
The
to
Dolores cases are all sensitive.
no, my lord, because all this is relating to the borderland, my lord. This is a matter for 3,450 acres of land, and their ownership is also not confirmed. Then after that, what happened, my lord? They are claiming the compensation for acquisition. They filed a writ petition, and I don't know, somehow writ
Madam, you
petition
are
was.
appealing for the government.
Yes, ma'am.
But the service is not complete. Service is not complete upon the respond number 1 to 10.
Oh, that I'll check it, my lord.
No, it's there in my report. I believe my registry.
Oh, no, thank you. That is absolutely right.
Still awaited.
Still awaited. And the notices were issued on
Yesterday's office notes.
yesterday's office note, huh? Or notices were issued on 11/6. So it's more than 2 months. Take fresh steps by tomorrow.
Yeah, I'll take it. So let it come on 4th of September. Then see if it is
1 month, okay.
1 month, okay. 4th of September.
Heard Mr. Y. Dolis, Learned Counsel for the applicant. And Mr. Dole, you say it's a very serious matter.
Yes, my lord.
Touchy matter.
Yes.
Then why this 541 days delay?
By the 541 delay required because what happened, this land is in between China and India.
The land is not going to come here to fight here.
No. That survey has to be conducted.
Why? You have not done that earlier?
Earlier, no. Subsequently, after this honorable single bench order, survey was conducted, my lord.
Okay,
to ascertain the things.
We'll see.
And that was the reason that they haven't, and everyday explanation has been given. Is it possible to, my lord?
We'll see. See the office note dated 3/8/2026, which reveals that the service of notice upon the respondent number 1 to 10 are not complete. The notices in the matter were issued on 11/6/2026 by speed post. Also, in view of the above, the applicant to take fresh steps for service of notice upon the respondent number 1 to 10 by speed post. Steps by tomorrow. Date to delivery. Register to, when do you want it?
3rd of September.
Register to list this matter again on 3/9/2026.
Author one matter, item number 3.
Mr. Modi, this is just an intra-court appeal. The findings of the learned single judge, we don't find it to be erroneous. It's a plausible view. Why should we now in an appeal overturn? And that too when there is no meeting.
My lord. Anyhow, my lord, let me explain, my lord, the reason why, my lord, I'm impugned against the order in the, my lord, single judge.
Payments have it.
Payment has already been done, Lord. So
You have received.
we have received, and therefore, other day I made a submission that his remedies lie somewhere else. He should go somewhere.
Now that same very land with your consent or non-consent, whatever it is, the money has been paid to someone. There is a procedure in that situation, and that is not a writ petition. If the apportionment has been done wrongly, you have a remedy somewhere else, not here.
My lord, this is the case. Exactly, it appears that the bond of contention is the compensation money. But that is not exactly, my lord.
You say that
what
land still is there.
My lord.
Whereas the civil court proceedings, your own declarations, the contention of the respondents project to a different line.
My lord.
So there is apparently a disputed question of fact.
My lord.
Why should we break our head on
My lord,
without evidence?
there is something, my lord, who is unable to, my lord, is find out that I'm trying to display, my lord. In fact, my lord, that is exactly my lord has raised that in the, my lord, title shoot, as per the title shoot, my lord, this title shoot has been declared in favor of the, my lord, private respondent.
And that pertains to this 49 point something.
My lord, yeah, 59 of 2008, my lord.
No, but the
Now, my lord,
land is 49 acres
My lord.
something, 49.63 acres.
what the, my lord, the first thing that could not understand by the single, my lord, just was that, my lord, the title shoot was withdrawn by me, my lord. Not only, not that, my lord, I have surrendered, but with a conditional withdrawal, my lord.
What was
There was a conditional. Before, my lord, in the, my lord, title shoot itself, my lord, this is clearly reflected that there was a amicable settlement between the parties outside. Now, by the outside, the discussion was that the land called the Hisham, that Hisham area is 100%, my lord. That land will be now belong to me as per that agreement. Accordingly, my lord, since the 100% Hisham is, my lord, allotted to me, therefore the person who are having the title shoot, that is the title shoot number 10 of 2000, my lord, this 3, they also withdrawn in view of the, my lord, settlement. Now the question before the prime, my lord, issue before the single judge was that, my lord, whether the land so-called Hisham has been encroached by the army authority or not, my lord. That is only I want to, my lord, that I am to point out that this is
the order of the learned withdrawing your, where is that agreement?
my lord. My lord.
167.
My lord will appear in 165.
165 or 167?
This will be 165.
Hey, 165. 167.
My lord.
Hisham area, তাত ধৰিল নে তাত এনক্ৰোচমেন্ট নাই, মানে ই সোমোৱা নাই, আৰ্মি সোমোৱা নাই, ই যিখিনি মাটি এৰি দিছিল এই মাটিখিনি তোৰ আৰ্মিয়ে এনক্ৰোচ কৰি আছে 49.63 acres, এইকেইটা পেমেণ্টটো কৰি দিলে। এতিয়া সি আহি কয় নহয় মোৰ হিচামৰ মাটি সোমাই আছে তাতে।
My lord, it appears there is a variation of the page. My lord, 167, my lord.
167.
Can my lord find in the 167?
Last page to the operating portion is in my table.
My lord, the English translation of compromise copy. My lord, got it?
167 is the
Judgment.
Yes, yes, my lord. Then, my lord, may kindly come back to 165.
Yes. English translation of compromise.
My lord. I'll not read out everything to bother the lordship, but my lord, the particular point, my lord. First, my lord got it, 165, compromise. Here, my lord, this is decided that all the members claim to the landowners of the army occupied area should enlisted in the PDBRATC2, the members from the Dego, Panya, Rigo, and the Bogdo village shall make complaint against this. This shall not complain against this decision. My lord, the operating is 2, my lord. Panya, Dego, Bogdo, Rigo, Alo Township Boundary Commission Committee passed and decided to hand over the 100% Hisham leave original land to Sri Kintori, it's me, my lord. And also pass that all the house constructed by the PDBRATC at the Hisham lands are also to be handed over to the
Mr. Modi, was there after this decree in your favor, was there a demarcation exercise carried?
No, my lord. That is, my lord, my main contention is that after this degree, since from this degree, I have been hankering after the deputy commissioner that there should be a demarcation because there was a landmark judgment.
Execute court, declarable land. I didn't have. I do. What is it? We don't get.
Chair heard Mr. C. Modi, learned counsel for the petitioner. Also heard Mr. What are you appearing for?
Respondent number 7. My lord, there is one small thing, my lord, if I can access the court. Kindly have this para number 12. The issue of demarcation of the impugned judgment, which my lord will find at page 146 onward. 144, my lord. 44. 144. Para 12. Because in Basar title suit number 59, my lord, 49.63 was already declared in our favor. My lord, kindly come to page 344.
344.
344.
Para
12 onwards, 12 to 12.1 and 12.3. No.
Or the impugned
judgment. The perusal of the impugned order dated 23/9/2022 indicates that the Deputy Commissioner heard Mr. B. Ori, learned counsel for the petitioner, Mr. Kentori and Mr. M. Nochi, learned counsel for the respondent, Mr. Gumsan Lolen and censor of the order dated 4/4/2022 passed by this court in read petition number source. It is further for the Deputy Commissioner to give a hearing, my lord. What the requirement was only for a fair hearing to him as to ascertain whether the land claimed by him still exists or not, my lord. It is for the Deputy Commissioner to give a hearing to the petitioner and determining as to whether the petitioner is the owner of any portion of the land that is acquired. If the result thereof is in affirmative, it is for the Deputy Commissioner to either include the name of the petitioner in the list of beneficiaries for the compensation, or else it is for the Deputy Commissioner to exclude the land of the petitioner from the acquisition. Then 12.1, kindly come. It also appears from the impugned order that the Deputy Commissioner has provided sufficient opportunities, kindly note it down, to the petitioner to substantiate his claim, and his counsel in the last hearing conducted 23/9/2022 had submitted a petition containing the contentions and the claims of the petitioner, which have been thoroughly examined. 12.2, then I come to another paragraph. It also appears that the Deputy Commissioner had outlined the claim of the petitioner. The petitioner has claimed that he has procured the army-occupied area, locally called Rago area, as gift. My lord, here Isam and Rago area is another thing, my lord. As gift in 1981 from late Ormo Lolen, great grandson of late Kimek Lolen, who was the original owner, thus claimed to be owner of entire army occupied area in the Basar title suit. 10, Kento Ori versus Diga 13 and others, the district and session court Bashar has declared title of the Isam land measuring an area of 30,227.8.85 7 acres approximate in favor of Sri Kento area. Now
12.3 is the conclusion.
12.3 is. So therefore, my lord, thereafter the Deputy Commissioner had found that no documentary evidences. He was given adequate opportunity. Kindly come. You produce the documents before me. Like, my lord, there is an English phrase we say.
It's only 7 acres of his, which he was finally found to claim to belong, included in that area. But out of that 7 acres also, he had sold out.
Sold out, and he could not provide any documentary evidence. My lord, it is his own submission, my lord, with the English phrase, my lord. Bucks walking into the purse, my lord. So given this leeway to the court to
Okay,
discuss this.
we'll consider. Mr. Modi is here. We will not ask him to not come on the first day. Heard Mr. C. Modi, Learned Counsel for the petitioner. Also heard Mr. You are appearing, who is appearing for the government?
Government and the CGC is also.
One for Union of India.
CGC,
Respondent 4 and 6.
respond number 1, 2.
My lord, will take
Three.
this on record. The compensation already been deposited. Vanisha, please pass over to their lordships.
5, land management also you will take?
Yes.
5,
1, 2, 3, and 5.
1, 2, 3, and 5. Mr. Learned CGC accepts notice on behalf of respond number 1, 4, and 6.
Only 4 and 6.
4 and 6.
4 and 6.
Oh, 4 and 6, sorry, 4 and 6. Who is appearing for 7? Mr. Tara, you will be.
I am appearing for that.
Also heard Mr. T.T. Tara, Learned Senior Counsel, assisted by Mr.
K. Lolin.
K. Lolin, Learned Counsel appearing for the respondent number 7. Full stop. As agreed to by it is submitted by Mr. Tara, Learned Senior Counsel, that the compensation in respect of 49.63 acres of land located at Bogdo, Aluf, West Siam district has already been released to the respond number 7. To the respond number 7 by
On behalf of
the beneficiaries, by the respondent authorities. Full stop. As agreed to by the Learned Counsel for the parties, admission of the registry to list this matter again on when?
My lord, after 2 weeks.
2 weeks. 4, 11, 18?
Let me see. I will check up this 18. 18. No, I will not be there. But okay.
20?
Tuesday concert dinner. No. 11 we have a DB, right?
2 weeks is that?
But 11
is only 1 week.
18th. But before this, like.
Okay, 11 we have no issue.
Yes,
Can keep it
11.
on 11 is 20.
After this, I might be out of station.
11, huh? For admissions.
Yeah.
Admission. Get.
Item number 12.
May it please your lord. My lord, this has been lifted for the first time. There is a delay of 38 days, my lord.
But what is the error in the judgment?
My lord,
you have done your exercise.
Yes, my lord.
You got an amount of particular estimated value, right?
That estimated.
One second. 3 crore something. You throw it up to the public by way of an advertisement. You invite bids. He quotes 12% below that.
No, thereafter subsequently when we have issued the ad hoc contract, the rate was much below, my lord.
Be that as it. And this rate is admittedly below the rate of
before
your estimated rate.
My lord, this earlier the writ petition was filed challenging on the same ground, my lord. That was withdrawn without taking leave of this honorable court. Again, they have come up with the same.
No, they have not come up. That bid, then he found that he was the L1 bidder. With that inconsistency also, he found that he was the L1 bidder. So he withdrew the writ petition. Now you reject that tender, you cancel that tender. He comes back. It's a fresh cause of action.
No, my lord. At this stage, my lord, notice may be issued in the IA, my lord.
For notice issue, it's not for just for the asking. We'll have to be satisfied that there is something in the.
My ground number 3 my lord, may be paid, my lord. Page 23.
Of the appeal?
Of the appeal, my lord.
Page number.
Ground number 3, page 23.
Of the appeal.
Of the appeal.
Maybe they can that information. It would happen in the classroom. No. Fully in the record. And not fully, he and not her. You draw with you. I was a fan that you will estimate it. That photo. It's an embarrassing political. Yeah, yeah, আমি তাৰপিছত আকৌ চালো মাৰ্কেট চাৰ্ভে কৰিলো ৰেটটো আৰু কম চ' আমি এইটো ইয়াৰ ৰেটটো এক্সেচিভ হয় কেঞ্চেল কৰিলো বেছি চিংগল নটিছ আপোনালোকে ইছ্যু কৰিব লাগিব ডিলেট ন Heard Mr. B.K. Singh, Learned Counsel for the petition. Also heard M. Kato, Learned for the applicant. It will go in the IA. Also heard Mr. M. Kato, Learned, this appearing for the Learned CGC. The present interlocutory application has been instituted, praying for condonation of a delay of 38 days in preferring the connected writ appeal. Also, issue notice returnable 4 weeks. Also, Mr. Kato accepts notice on behalf of
Respondent number 1 only.
no formal notice is to be issued. However, requisite extra copies of the interlocutory application be furnished to the learned CGC. Also, petitioner to take steps for service of notice upon the respondent number 2 by way of speed post steps within 3 working days from today. Registry to list this matter again after 4 weeks on a date to be fixed by.
Obliged, madam.
Item number 13.
My lord, there has been a delay of 106 days in preparing appeal against the impugned judgment of the learned single judge, my lord. The delay was due to lack of communication because the applicant is residing in a place where there is no mobile network. So when the place where he is staying is Tama Chung Chung, my lord.
What is the error in the judgment?
My lord, I have prayed for your lordship will find in para 2 of the judgment, impugned judgment, my lord. It says, my lord, extraordinary jurisdiction of this court under Article 226 of the Constitution of India is being sought to be invoked by the petitioner for issuing direction to the respondent authority for payment of compensation for acquiring of his private land and interest on the compensation amount from the date of taking possession of the land amounting to rupees 16 crore 97 lakhs 74,490. Alternatively, it is also prayed for issuing direction the respondent authority to vacate the said land after payment of lease rent for 18 years amounting to rupees 13 crore 62 lakhs 17,172.96 paisa. This was my prayer, my lord.
So you were given a lesser amount of compensation.
No, my lord. They have proposed to acquire 19 acres of land. For that, 4 crore something amount was sanctioned. I was not paid that amount. Then they have proposed to acquire only 4 acres, my lord. I refuse to.
Only 4 acres.
Only 4 acres. I refuse to give 4 acres to the ITBP. I want to stand by the earlier notification, my lord.
Heard Mr.
S. Going, my lord.
S. Going, Learned Counsel for the petition. Also heard Mr. G. Kato, M. Kato, Learned CGC, and Ms. G. Ete, Learned. Your additional
Senior Commander.
Senior Government Advocate. Kuso. The present interlocutory application has been instituted, praying for condonation of a delay of 106 days in instituting the connected writ appeal. Kuso. Issue notice returnable 4 weeks. Mr. Kato accepts notice on behalf of respondent number 1, 2, and 3. while Ms. G. Ete accepts notice on behalf of respondent number 4 and 5. So as all the respondents are represented, no formal notice is to be issued. However, requisite copies of the interlocutory application be furnished to the learned counsel for the respondents. The learned counsel for the respondents are at liberty to file their respective objections to the prayer for condonation of delay before the next date of listing. Registry to list this matter after 4 weeks on a date to be fixed by.
Well, actually, the impugn order, the impugn order which he has been impugned has been the passed on consensus opinion agreement arrived between the parties. I am appearing as deputy solicitor, madam.
Oh, sorry, deputy solicitor.
In both the cases.
It's been 1 year, no? So changes I have got. Sorry.
Item number 14.
Unlisted I.
Not yet. Lordship, this matter is represented by this advocate from Gauhati, Manojit Biswas.
Oh, when Mr. Tapak is here, why we require somebody else? Mr. Tapak
He's the
this matter is pending like this for a long time.
That is why. This is
In fact, what has happened is this matter was fixed on 21st of July. For some reason, it didn't come up and it has come up now. And in fact, I also suffer from the handicap that I am not carrying my brief. It has suddenly come up.
Oh.
So Mr. Biswas called me up and he apparently is in Aizawl. So
he's a busy man.
Busy man. Any appropriate date as per the convenience of senior counsel.
Let it, this also be on 8th of September only.
8th September.
8th September.
All three I'll do on the same day.
As agreed to by the learned counsel for the parties. A prayer is made on behalf of Mr. M. Biswas, learned counsel for the petitioner, for an adjournment in the matter on the ground of personal inconvenience. Mr. I. Chaudhary, learned advocate general, Arunachal Pradesh, is present. So, as agreed to by the learned counsel for the parties, registry to list this matter again on 8/9/2026.
Item number 15.
Please, Your Lordship.
Anything survives here. You have been given the proportionate marks.
Lordship?
Proportion marks have been given for the questions.
No, my lord. No.
Not given.
No, my lord. My lord is perhaps confused with another matter.
Which is that? What is this?
No, there was a lordship. The reason why this matter was pending for so long is because, yes, because there was a submission made on behalf of the APPSC that that similar matter is pending before the Honorable Apex Court. But it turns out that the facts are totally different there.
That's a different matter.
Yes, and they were supposed to actually bring this on record, but it was brought on record very late. So that is why. But, Lordship.
Okay, what's your case?
My case is simply that of re-evaluation, my lord.
Where is the provision for re-evaluation?
There is no provision for re-evaluation. That is their case is there is no provision for re-evaluation. My case is
now the issue is it's crystallized now by the
yes, my lord. Yes.
Re-evaluation is something which has to be provided by the rules or the advertisement.
My lord, I'm my lord. I will be only my lord relying on the Ranvijay case.
But there are decisions after that also.
Lordship, if in that lordship, it may not be that re-evaluation, even if there are.
Okay, show me the nature of the questions that you are claiming.
Lordship, I have actually prepared a chart just to show, Lordship.
These are descriptive type questions?
No, my lord, objective type. Or it's like grammar, more or less objective.
Objective.
Yes, it is not exactly objective, but your lordship knows grammar questions are such that there is only one word which can be right. So that is why I'm saying that. I have mentioned the page numbers also. Before that, my lord, may I, my lord, apprise this honorable court?
What is the first evaluator, second evaluator?
There are two evaluators for one paper. If the first evaluator gives some marks, second evaluator gives some marks, then there is a division of the marks. If the first evaluator gives some marks and if the second evaluator doesn't give marks, then it is zero.
Total zero.
Total zero. Because there are two evaluators, so it has to be divided.
Divide.
Yes. What I'm pointing out, Lordship, by this, Lordship may see, what I'm pointing out by this is that.
Where is question number, that first question in your, this answer scripts you have brought on record?
Yes, page number 307.
307.
Lordship, that is not the only issue, Lordship. I am seeing, Lordship.
Where is your answer?
Lordship, answers will be.
This is the question.
Yes.
$272. Where is your answer, madam?
Lordship, sorry. It will be in the. This is general English. I'm sorry, I should have marked that answer sheet, Lordship.
Okay, will not, you do that, entry that. But that's the only thing we have to look into.
Yes, Lordship, there is one thing I would like to point out. Very crucial here, Lordship. What happened is not that, it's not just that I have not given any marks. It's also that, I have mentioned here also, it's also that other candidates whose answer sheets I was allowed to peruse by way of RTI. But for that RTI also I had to take a long road because the PPSC had challenged the order of the commission to let me peruse the marks. There was also challenge before this honorable court. This honorable court dismissed that petition and I was allowed to peruse. When I perused that, my suspicions were confirmed because so many candidates on the very same question, on the very same answers, they were given marks. This is what I have enumerated in the column 4 of this sheet that I have given, Lordship.
Marks given to other successful.
Other candidates. It is not just a matter of whether the answers being right or being wrong. It is also a matter of that other candidates who have qualified for the exam,
They have been given.
they have been given marks. Not just one, so many candidates that I have enumerated here, Lordship.
For the same answer.
For the same answer.
There was an answers key for this?
No, Lordship. No answers key.
This is the final examinations.
Yes. I have missed the mark by only 1.84 marks. The Honorable single bench had only, my lord, dismissed my case based on technicalities, saying that I have not implemented the other candidates, that I have not met consequential prayers. Those two things, Lordship.
Other candidates.
Other candidates. But the other candidates will depend on the result of the evaluation, in my humble submission. I cannot simply say that he or she should be dislodged because it will depend on the marks which I would have gotten maybe by way of re-evaluation.
60.
I'm extremely sorry, my lord. I'll mark it here.
Bottom answer. Question to us, 307. Just seat along with 307. I got a fresh new supply of fresh water. New supply of egg, but I cannot say whether they are fresh or not. Right. Apparently, who is it? Somebody on the phone. He's right. News got a news of Yes, madam.
Yes.
What is your stand?
The state commission is representing your lordship.
No, forget the state commission. We are
He is the
with
recruiting.
the government. State commission is over. You mean to say that the Assam, Arunachal Pradesh public service?
Yes, your lordship.
Who is there?
Yeah, Apang sir, sir.
I'm here, Lordship.
Typing through seal.
Oh,
See.
Lordship, I'm here.
I was thinking I have not seen Mr. Apang here this time when I have come.
Lordship, I have some physical issues as well, Lordship. I'm out from here.
Okay. No issue. Please go ahead.
Lordship,
There seems to be some error in the marking.
Lordship, there cannot be one examiner upon examiner. Once
No,
examination,
she says that there were two examiners,
Lordship.
and
Now,
for the same answer, two
procedure
views
is
have
like this,
come.
Lordship. Two examiners, they will mark separately, and then both the marks will be compared by taking the average. Average is taken.
So 0 plus 2 will be 2, not 0.
Lordship, that 0 plus 2 is 2. That is right. But
So she says that she has not been given that 2. If she gets that 2, she is through.
Lordship, then she has to make respondent to other parties also, other candidates also.
Oh, we'll come to that. Let us first understand whether, because there is a question here. I have got dash supply of eggs, but I cannot say whether they are dash or not. So you got to incorporate fresh and new. So the only way we can read it is I have got a new supply of eggs, but I cannot say whether they are fresh or not. So one of the evaluators gave a 2 for that, rightly so. The next one gave 0, and she was given 0. How do you say you were given 0, madam?
Lordship, we'll find at page 71. This is the mark
6B.
6B, Lordship. 6B with 6B, yes. 2.
Total marks they say is 1.
Lordship?
6B2.
6B2, page 72.
Yes. 2 marks.
This is the first evaluator. Second evaluators will be at page 74.
How many questions were there under
0.
6B?
0.
How many questions were there under 6B?
6B, 5.
5 questions.
Yes.
So 2 marks.
2 marks. One evaluator has given 2 marks. The other one has given 0. Just Lordship will find.
Here, if you come to that, where is the other evaluators marking?
That is page 74.
Page 74.
74.
The average has to be taken.
Yes.
Average of the 2 marks.
Yes.
2 plus 0.
But he has given here as 1. Why? In page 73, 6B, 2 is 1.
This is 5B, Lordship. Page 73 is question answer to 5B.
No, 74.
And where is the other evaluators marking?
Other evaluator 74. 6B, 2, 0.
72.
Yes.
72 to page 72.
Page 72 and page 74. Lordship may compare
One
page
is given 2, one is given 0.
0.
And what was the final marks given to you against this?
The final marks,
Plus 0 is 0 given to you.
It is like this. Suppose the first evaluator gives 2 marks. Second also give 2 marks. Average will be taken, I'll be given 2 marks. Now in this case, because one evaluator is given 0, I'm given 0 marks.
No, 2 plus
where
0
do we get
divided by 2.
That is the procedure as per them, Lordship.
No, where do we get, how are you making that submission?
Lordship,
2 plus 0 divided.
this will be found by the
Average. One. Yes.
total marks, Lordship.
No, where do I get that you were given
Yes,
0, not 1? Because average would be 1.
Lordship.
2 plus 0 divided by 2 would be 1.
Yes.
So where do I get it that you were given only 0 and not even 1?
That is what they are saying, Lordship.
Where they saying?
They said it by way of submission, Lordship, but that is what I understand, Lordship.
Your understanding will not do.
Yes. The other candidates, they have been given total marks. That is 4.
Got it. How do you say that you have not been given even 1? Is there a third sheet of evaluation wherein both these marks are added?
What happens is all the total marks of these 2.
Mr. Apang,
Lordship.
now we have 2 papers, 2 evaluation sheets of 2 evaluators.
Lordship.
In one, it is given as a 2. In the other one, it is given as 1. Now, is there a third sheet wherein both the evaluators' marks are averaged out and a list is prepared? You have a list like that?
Definitely, Lordship. There must be a final, Lordship.
Where is that final list?
So it is
Where
not
is that
there.
final?
It is not there. In fact, Lordship, it's a very, very long, the old case, wherein
As a case is pending, so the records, at least this marking records would be with you.
Lordship, records were earlier produced. That was returned back. Earlier, when first order was passed, before that, the records were produced before the Honorable Court. Then the records were returned back after verification only that London single judge has passed that order. Now, after that, Lordship, again, APPC fiasco in recent 2020 or 21, all the records have been seized by the CBI. Now APPC is empty.
Lordship will find at page 211 is the final mark sheet. In this paper, Lordship, I have been.
I accept.
Yes.
We accept all your press.
Lordship.
We accept your press. Somehow on a assessment, you only won 1.86. We give you 2 marks.
Not only this, my lord. There are other questions, my lord.
No, you only require 1.86.
84, yes.
You come in.
Yes.
Give you 2.
Lordship.
Giving you 2. Take it. Now tell me what should we do? We can't proceed any further because the posts have been filled up.
Yes.
And those persons who are there are not before us, and without hearing them, how can we set aside their services? And that too, after 12, 13, 14 years.
Lordship.
So on that count, we'll have to dismiss your application.
Now those appointed as DSP has become SP.
SP. So I think we'll give it a closure.
My lord, there is something I'd like to say, my lord.
Please do so.
The delay in the petition.
I'm not on the delay.
Lordship.
I am only on the consequence.
Yes.
The persons whose rights would have been effective.
Lordship, Lordship, at that point of time.
You have not even endeavored to make them parties even in the writ appeal.
Yes, my lord.
And there is a categorical finding of the learned single judge.
Yes.
That in absence of these persons, we are not in a position to. In spite of that, the appellant was relaxed. 1983 Supreme Court. Once an opportunity is given, not taken up, that's the end of the matter. I hope I'm right, Mr. 85. So.
I leave it to your lordship.
Okay. Dismissed.
Obliged.
Next time, Mr. Dangan. Ms. Dangan.
Item number 16.
Item number 16. Rule amended.
Well, Lord, I believe
My lord,
whether
rule is, my lord,
sunshine or the rain, this case must be come to an end. 22nd September, my lord, 2022, they have filed the affidavit. And since then, they have been making a statement before this honorable court that rules are being amended. Now, much water has flown beneath the breeze. And when it is going to end, nobody knows, my lord.
No, it's from here. It's from here.
We have time. We can hear this one.
my lord, once my recruitment rule, my amendment process is started.
That is there for the
my lord.
last, I think, 2 years.
Obviously, there will be end, my lord.
4 years.
There will be end, my lord.
Let it be, and we will end it before that, if required. Yes, what is your grievance?
But
Page 33.
yes, now there
What
is
the error?
there is a three recruitment rules. First, the assistant inspector recruitment rule, my lord. Before that, my lord, there are 47 petitioners, all serving constables and head constables in the Department of Tax and Excise, Narcotics, Government of Arunachal Pradesh, with 16 years and more of continuous service, now almost 20 years now.
Department of Excise.
Yes, my lord. In brief, my lord, I'm making a very narrow submission, my lord. And I believe it emerges quite clearly from the rule themselves.
Earlier it was constable,
yes,
head constable, ASI.
Correct. So
then head constable was taken out. Constable to
no, I can give this one. Now, state's own recruitment rules, my lord, allows a constable to be promoted directly to assistant inspector, but deny that same promotion to the head constable, even though a head constable is senior to and drawn from the very same feather cadre of constable, my lord. Now, here I am to submit, my lord, to show that these cannot stand scrutiny of Article 14 and 16 of the Constitution. These, my lord, will kindly see first.
Okay, Mr. Tara.
Page 41, my lord, Annexure 5.
Just reframe the submission.
Yes.
You mean to say earlier it was from head constable to?
No, my lord. Earlier it was from constable to directly to the assistant inspector, tax and excise.
ASI.
Yes, my lord.
Then
thereafter, 16 of them have been promoted from constable to the assistant inspector. Then in 2009, there comes 21, they frames the rules of head constable. And unfortunately, my lord, the head constable does not have any way, my lord. Their seniors in the earlier recruitment rule, my lord, assistant inspector recruitment rules, my lord. The 40% promotion avenue is.
Where is that?
My lord, kindly come to page 41, 2009 rules, my lord. My lord, I start from this, Annexure 5, my lord. Please kindly see, my lord. In exercise of the powers conferred by proviso to Article 309 of the Governor of Arunachal Pradesh, hereby makes the following rules. Further, to amend the recruitment rules for the post of Assistant Inspector, Tax and Excise 1997 in the department.
No, this is the amendment rules. Where is the original rule?
Original is at page 31, Annexure 2. No, sir. No, my lord. Annexure 3. 32. 32.
No. I think it is.
1995. 35. 1997. 35. my lord. 35. no? My lord, we'll find type copy. My lord, comes to the schedule straight. The type copy is at page 40.
Page 40.
Page 4040.
Page 40.
40.
No. Method of recruitment.
I'm coming straight away to the schedules. Method of recruitment, whether by direct recruit or by deputation, transfer, and so and so. 100% by direct recruitment through a written test, following so and so general knowledge. This is one. Number two, in case of recruitment by promotion, deputations, transfer, grace from so and so, so then by promotion from head constable, my lord. By promotion from the head constable, my lord. So there is then my lord will come to page 41. This is the amendment, my lord. G. Amendment G. Okay, annexure forums, Lalan, page 34, 34, madam.
What has been amended?
Here, my lord, the amendment is kindly see, my lord. Serial number 3, rule 3, my lord. It says 40%, 50% by direct recruitment on the basis of open competition through so as a common recruitment examination scheme notified by OM dated so and so. Then 50% by promotion as prescribed under column 12, my lord. Then, my lord, will kindly see after in this B, 10% by promotion from amongst the serving lower division clerk, my lord. Thus, they have also kept it, who have rendered 6 years of regular service in the grade and possessing educational qualification prescribed under column number 8. Now, B, my lord, 40% by promotion from amongst the serving constable who have rendered teaching education prescribed under column 8. Now, my lord, then there is no scope for the promotion of the head constable. That, my lord, will see it annexure. Annexure 4. No, my lord, annexure 4. Iska baat ho rahi thi. Now, there is a recruitment
Just
rule.
a minute, sir. No, originally we have to go to 007. Huh?
Page 32. Page
Now,
32.
now, Mr. Got it. You got your point. There is a recruitment rule for promotion from constable to head constable.
Now they brought in.
There is a rule.
Yes.
Then the original 1997 rules was 100% direct recruitment. If there was maybe no person available for direct recruitment, then maybe by way of promotion.
Correct.
But it's a direct recruitment post. And the direct promotion is from the cadre of head constable.
No, my lord, constable.
No.
No, no, no.
In the 97 rules, it is
97,
head
yes.
constable.
Head constable.
Come to page 39.
40 is clear,
No,
madam.
no, no,
Type copy.
39. Type copy.
Type copy is 40, madam.
Type copy, Mr. Tara had made it, so he may have some doubt on that.
It's doubtful, ma'am.
We'll go for the
Original.
by promotion from head constable.
Yes, constable, correct, madam.
So head constable is the predicate.
Correct.
Now, when they made this 2009 rules,
Then that
they forgot the word head to be added in B. Right? Now, tell me, over the period of time, recruitments are being made from, the recruitments by way of promotion is being made to the cadre of ASI? Are promotions being made to the cadre of ASI? Over the period of time
No,
after
no.
22? No promotions
No
till now.
promotions.
Why?
Because in the recruitment rule, my lord, I have seen, there is the word head constable is omitted.
No, I'm not on that. Any promotion made to the cadre of ASI after the amendment of 2009.
31.
Huh?
Page 31.
30?
31. my lord. 14 constable to the post of assistant inspectors.
After this?
Yes.
After this, any promotion?
After this, my lord, 6 constables were promoted to head constables.
Okay. These people were promoted as
assistant.
And you all are head constables.
No. Here is a combined, my lord.
That's what I'm asking. How can it be a combined one? I think I have asked you this question on the last occasion also. The constables can have got no grievance here.
Correct.
The grievance would be with regard to the head constables only, because they are in a higher cadre. So who are the constables and who are the, because there are around 47 candidates.
7.
So all are not head constables.
The post title.
So this is a clear case of misjoinder of petitioners, because the constables can have no grievance.
But the head constables.
Let them give up the promotion, to, forego the promotion to ASI.
I will satisfy that.
Who are the head constables and who are the?
Well, there are head constable don't. No, I assist this.
Cost title में clear कर देना चाहिए.
है sir. Constable है, head constable है.
We have not said in the cost title domba.
No, दो पास है.
हमें सिकात के one kata bagai kada. Nothing. Head constable.
No, I think
constable nothing.
You have made them party respondents here.
Well, just I'm trying to give it.
You have also not arrayed them as party respondents. So that promotion in all probability we cannot touch. And the constables are not at anyway.
No, they are nowhere.
Give a declaration to the effect that these rules, apparently, in view of the head constable rules, does not appear to be correct.
We are seeking that much only, my lord.
And but these promotions will be protected.
The promotions we are not.
You're not claiming.
No, we are not claiming.
Yes. What is this, Mr.
And my lord, a small thing before the learned additional AG answers it. But that other day I was flipping through a judgment. Although, my lord, this 1989, my lord, the Supreme Court Employees Association case, 1989 for SSC 187, my lord. In para 51, the court is very clear that court cannot direct by issuing a direct a legislature to enact a particular law.
No reason for that. We don't have the power to.
That is one thing.
We can't ask them. But we can only declare that thing is.
So therefore, my lord, it says that paragraph 51 of that judgment says, there can be no doubt that no court can direct a legislature to enact a particular law. Similarly, when an executive authority exercises a legislative power by way of subordinate legislation pursuant to the delegated authority of a legislature, such executive authority cannot be asked to enact a law which he has been empowered to do under the delegated legislative authority, meaning thereby we cannot
This is
issue a
not
mandaments.
delegated legislation.
Yes. So
This is legislation under 309.
309. So therefore, my lord, now what had happened is
So Tara,
the Supreme Court.
yeah,
in
that is very confused.
Yes.
Now we'll
The
get this
Supreme
confused
Court,
with
my lord.
these big things.
Now, as simple.
Yes, Mr. Nawab.
Yes.
What is this happening? See, you could have done it in a very easy manner. Okay, the promotions will be from the cadre of constables. But any head constable who has been promoted to the cadre of, any constable who has been promoted to the cadre of constable will be considered for this purpose as a constable. He'll be in the top there. Promote, finished.
My lord. My lord, perhaps because of that, my lord, the recruitment rule 2009, my lord tried to explain the things. But something went wrong. If your lordship sees...
The word head is not there. Only thing is that the head is not there, the body is there.
Yes, my lord. Because of that, because of that only. My lord, if your lordship says, my lord, this 2009, this amended recruitment rules. Others, my lord, this 50% for direct recruitment, 50% for promotion. But there is a riders, my lord. That is the troubleshooter, my lord. The entries in the column 12 shall be substituted by the following entries. That is the troubleshooter. Otherwise, my lord, column 12 talks about the head constable, my lord.
No issue.
Yes, my lord.
No issue. Now, you tell me, if a constable, now we'll look at it a different way. A constable, there is a vacancy in the cadre of head constable.
My lord.
He gets himself promoted to that cadre.
From constable
Whole
to
service,
yeah.
whole service, he'll remain a head constable. Whereas a same level officer is, by virtue of something he was there, a post comes up in assistant sub-inspector, he gets promoted there.
My lord.
Now, how can you, this is a dichotomy, how can you?
My lord, to get a promotion to the post of assistant management inspector, my lord, there were 3 channels, my lord, initially. LDC, constable, and head constable, my lord. Now, my lord, as per this new recruitment, proposed new
Have you done away with the cadre of head constable?
You may kindly bear. A presentation was submitted by the head constable saying that there is discrepancy in the recruitment rule. This need to be amended. The promotional able cadre post is only the head constable, my lord. The process is on, my lord. Now, my lord, now what extent, my lord, that process they have succeeded on that, my lord. I have to take instruction, my lord.
Okay, Thursday.
Thursday, my lord, very well.
Para 7, 8.
Then
Sir, petitioner number 3 is the head constable.
only. Only one.
Only one.
No issue. Then you have to clarify this.
Where is a joint? Oh my God.
Join misadventure.
There was trial and error basis.
Sari bosor pa ko. 2022. Now, my lord, now Mr. Tara has corrected, my lord. Only petitioner number 3 is the head constable. Rest are all constable, my lord. The second things, my lord, they are not agree with the promotion given to the constables, my lord.
We'll say these constables don't want the promotion to ASI. They'll be considered
I'll meet your lordship, my lord.
head constable only. Thursday. And we want a firm thing. Otherwise, we are interfering with everything.
My lord.
A police department, we don't bring us to interfere.
This is not police department.
Anyway, that gives you the money thing to run.
That is the mala fuel, my lord.
Heard the learned counsel for the parties as prayed for. Raised it to this Thursday already? Thursday.
Thursday.
Mr. Chaudhary, what are you waiting for? Next person. Oh.
I don't know whether time will permit, that is the only.
18.
17.
No, 70s. Oh, that, our act unlawful. That would take some time.
And I'm told there is some unlisted matter also.
Two
Yes.
unlisted matters. Yes.
Lordship, I am ready, Lordship.
We are also ready, but we have a time constraint.
Lordship, it can be fixed tomorrow, Lordship, for the time.
Because this will take some time.
Exactly,
We'll have to
Lordship.
go and examine each of the provisions to see whether the constitutional or not.
But the issue is, my lord, there are no specific pleadings to, that's why we have.
More the difficult. But we'll have to see whether it gives unbridled power to the authorities or not. That's the only thing I think we'll have to go into.
Otherwise, legislative competence is not in question.
That cannot be. And what about the challenge to the similar acts? There was one challenge in the Supreme Court also, I suppose. No.
Not to my knowledge.
Yes. What is the basic challenge?
Lordship, basic is, Lordship, this doctrine of the repugnancy, there is already central act, Lordship.
Unlawful.
Yes. And then, Lordship.
Receive the assent of the president?
No, Lordship, not at all.
The Central Act is that is the National Security Act.
It is
They operate in completely different fields.
No, Lordship, it is preventive detention act. Clearly written
Might
in
be
the...
preventive detention, but the field is completely different.
No,
there it is for national security.
No, Lordship, it comes under this concurrent list, Lordship. Entry 3.
Yeah.
The Constitution.
Mr. Chaudhary, Maharashtra has a similar act, I suppose. Other states also have.
There are,
but I've read somewhere.
Yes, Lordship, they have taken the assent of, because exactly Makoka and there are many.
You say that they have taken the assent of the president.
Exactly, Lordship, they have complied the directive principle of state policy.
56
because
to 54.
Lordship. And every state has, but they have go through the directive principle state policy, Lordship. And moreover, until unless this act is placed under the Schedule 9, Lordship, that it is when there is a force of the, this challenging.
That's beyond that. That need not be.
this matter, my lord, let it be on 27th. I have been told that there is another matter fixed. 27th is a Thursday.
As agreed to, you have any problem on 27th?
Lordship, let it be on this week, Lordship, because
tied up, because we have fixed many matters.
Lordship, on Monday, Lordship. 29.
As prayed for by the Learned Council for the parties, a registry to list this matter again on 27/8/2026. An endeavor would be made to dispose of the matter on the next date of listing.
Obliged, Lordship.
Unlisted matter, item number 26.
Unlisted. Unlisted.
Yes, yes.
How many unlisted?
Only one.
Wait, please, Your Lordship. Lordship, this is against the impugned order of the learned single judge refusing interim protection. If my lord comes to the impugned order from page 93, it starts at page 94. I'll read the order since it's before Lordship now.
No, we have read it. What is your grievance?
Your Lordship, the operative portion, page 95, the second last paragraph. Having considered that the petitioner prima facie appears to be in occupation of government land unauthorizedly, that too adjacent to the government quarters, and has constructed the structure in between type 3 government quarters, no interim order can be passed. It has also been submitted by the learned additional senior government advocate that the said area is required for construction of a multi-storied building for employees of the state government, and similarly situated persons who have been found to be in unauthorized occupation have been evicted. My lord, in this case, my lord, the multi-storied quarter has already been constructed. My plot is adjacent to it, no doubt, but it is not in between two government quarters.
No, earlier two government quarters.
No, my lord. The other part was a vacant plot.
What is your right to occupy this land?
My lord, there is a notice. In fact, this particular land was purchased by my father. Yes.
Cabinet decision.
Yes.
Not implemented.
Cabinet,
Have you filed any proceedings?
I have. My lord, representation at page 49.
Representation. That's a government decision.
Yes.
Admittedly, the procedure has been followed.
No.
You have got no grievance with the procedure followed.
My lord, at page 49, they have not disposed of this representation at all, sir. Page 49 is of 2015.
Fine.
Now, this I rely on the cabinet decision.
Cabinet decision is gone.
But the cabinet decision, they have communicated.
You have not taken any steps in between. Would have come to this court, prayed for a direction, they are not doing it.
Lordship,
now that the government need is there, they have done it.
Lordship, we have preferred the appeal. As against the appellate order, we are before Lordships. And even in 2020.
Order?
Yes. Page number.
The appeal was not disposed of when the learned single judge had passed this order.
Disposed of?
It was after?
Not disposed of.
Till now, not disposed
of. Till now, not disposed of. It is pending.
Okay. Who is appearing for the government?
Government.
Mr. Ratan, why this appeal is not disposed of?
My lord, I have no instruction in this matter.
You have your instructions?
Yes, ma'am.
It was filed on 15th of July, 2006.
July, 15/7.
Yes.
Not much time. Take instructions. Mr. Appeal hearing is to be given. No notices issued to you.
No.
We'll take it up on Thursday. You come online.
My lord. Or, my lord, could it be taken up tomorrow then, my lord? Because otherwise they'll begin the demolition of my house.
Son will ensure they'll not do anything.
Let's see, because it's moved unlisted.
Give him a copy.
Of course, man. Of course.
We'll have it on Thursday. You come online. There is no issue.
My lord.
And max we can do is
Okay. I'll say that. My lord, there is another aspect that appeal which we have preferred, it has been reverted to the estate officer.
Why?
That is one of our grounds, my lord. Estate officer, estate officer who issued the eviction.
How do we know? Sir?
How do you? That cannot be
from the office.
from the office has informed.
Where do I get any reference to that?
There is no document, but that is my instruction.
Heard Mr. P.D. Learned Counsel for the petitioner. Learned Senior Counsel appearing for the petitioner, assisted by Mr.
A. Tatak.
A. Tata, Learned Counsel for the petitioner. Also heard Mr. R.
N. Ratan.
N. Ratan, Additional Advocate General appearing for the state respondents. The present intercourt appeal has been instituted, raising a grievance
against the refusal of an interim direction by the learned single judge against assailing an order dated 29/7/2026 passed by the learned single judge in WPC number 346/2026, rejecting the prayer of the petitioner for an interim relief. Mr. P.D. Nayak, learned senior counsel appearing for the petitioner, has submitted that against the order passed by the estate officer, against the order dated
Order dated 18/6/2026
passed by the estate officer, the appellant had filed an appeal on
appeal is page 15/7
on
15 July 2026.
On 15 July 2026 before the Deputy Commissioner, Jurisdictional Deputy Commissioner. He submits that as per the information received, the said appeal has now been remanded to the estate officer. Mr. N. Ratan, learned additional advocate general, submits that the matter be taken up on Thursday, and in the meanwhile, he shall complete his instructions in the matter. Full stop. Accordingly, registry to this matter again on Thursday. Mr. Ratan, if it has been remanded back, that means there is some error, so that order of eviction cannot be.
It should not have.
You please take care that till Thursday nothing is.
Yes.
You come online.
My lord, could an observation be made about not taking it?
My lord, otherwise the learned single judge has also said that
appeal be considered.
Yes, ma'am.
Nothing will happen.
My lord. Deeply offended.
If something happens, we are there at 12 o'clock also, don't worry.
My lord, deeply obliged.
Item number 18.
After that, maybe the health condition may not.
My lord.
Yes, madam.
May I please, your lordship? Issue is, lordship, cancellation of recruitment process, and
Participate with 3 months in. It's a bit to page 36. Para 12. Para 12. Yes. Madam, cancellation grounds, okay. Debatable.
yes,
But after the cancellation, there was a fresh advertisement.
yes,
And you knew about the cancellation.
yes,
You, without any objection, submitted your candidature against the second advertisement.
yes,
Thereafter, you have come and filed a writ petition saying that why the cancellation is to be not.
lordship. That I am not disputing, my lord. But
You
subsequent,
accused to the second advertisement, that means whatever is there, you have waived.
lordship,
You should have come to this court, contested the matter, taken a liberty, then appeared, we would have understood.
lordship.
This is just taking chance. And the
But in any case, lordship, in any case, I have received instructions that my candidature has been rejected. due to overage.
In the second one.
In the second one.
Can't help it. You made that. For that, you can go ahead and that selection process is over.
No.
File an application before this before the writ court.
Lordship, in view of this order, my
Will not touch this here. Will not touch this.
no, Lordship, in view of this order, I probably cannot
Why?
agitate the same thing again.
No. This learned single judge has said nothing
Yes.
other than a passing reference that you have applied against that.
Yes.
Nothing has been said about the second advertisement.
Yes.
So if you withdraw this, I'll give you the liberty.
But the learned single judge order is standing in my way.
No, that is only with regard to the first advertisement.
Yes.
Not to the second advertisement.
Yes.
Yes, Mr. Kato.
Yes, my lord. Moreover, my lord, in this matter, my lord, the selection, my lord, which she claims to be, my lord, the communication is not, my lord, publicly published.
Forget the first selection process. It's gone.
My lord.
You issued a second advertisement in 20.
Yes, my lord.
She says that the selection process is not complete.
Yes.
Till now.
Till now, my lord.
But her candidature has been rejected on the ground of being overaged.
My lord, rejection and acceptance is one thing, my lord. At least she applied, my lord. That part, my lord. Yes.
Mr. Kato, we have already, I think Mr. Ms. Dangan has accepted that.
Yes, my lord.
Now, the second advertisement, she has a grievance that her candidature has been rejected on the ground of overaged.
My lord.
That issue we can't consider here.
True, man.
So if she wants to assail that, it's open to her to file appropriate proceedings. And then on merits, whatever happens, happens.
Yes, my lord. That part, my lord, at least we can, my lord, consider.
My lord, I'll need to take instructions. Can it be taken up on Thursday?
Done. Madam, you have got no right, and the reasons assigned seems to be not the communication manner in which your results were sent. No. You also knew about your results.
Yes.
So there was a disclosure of the results even before the results were finalized. Be that as it may, no malified error, nothing is there. But their case is that the entire structure of that university or that institution was changed. So if that be so, a new institution literally had come into being. So they said that whatever recruitment, it's not the cancellation of only your post. All the posts advertised, cancelled.
One post got lost in the way.
One UDA post somewhere.
Yes.
It's gone.
There is something there.
Maybe that post has been utilized for some other post. Because earlier it was 2, now it's only 1. Thursday.
My lord.
If you want to invite us, we will pass orders, but again, we will not touch the second advertisement. We'll only limit ourselves to that. Only take a plea, take a ground that you had appeared in the second advertisement without any liberty from this court. So you had waived your accused your right with regard to the first advertisement. That much we'll say.
Okay.
If you withdraw, we'll give you liberty recording your submission. That it is up to you to proceed before the writ court.
Just to brainstorm, my lord. Because one post got lost in the way. They have advertised only for one post.
That, madam, is not our that is his jurisdiction. That we will never get into. What is beyond us, beyond us.
Because if the
Mr. Panning to asking Mr. Rattan to get the roads cleared, that we will do. That is a personal interest involved in. For this, we cannot.
What I'm saying is, Lordship, what I'm saying is, suppose my writ petition is allowed. There will be 2 posts.
Which writ petition?
I mean, this writ appeal is allowed.
See, madam.
Yes.
The cancellation, recruitment, or appointment is all within the domain of the respondents.
Yes.
If they can come up with an explanation as to what they have done with one post, and it's a plausible explanation, the law is that we'll have to keep our hands away because we are not the persons running the administration.
Yes.
It's a settled position of law.
My lord, Thursday. Oblige.
As prayed for by the learned counsel for the appellant, registry to list this matter again on Thursday. No, I'm sitting in a division bench after a long time. So it's only still petitioner in my mouth. Appellant is not coming out.
I thought my lord was talking about paucity of time.
No.
I won't take much time on Thursday.
No. No
Obliged.
paucity.
Item,
No, madam, we have disclosed what we think is
Yes.
a tentative opinion.
Yes,
If you can convince us, fine, we are ready to change our views. Otherwise, why waste time?
yes,
Finish off the matter.
I'm obliged.
item number 21.
It's always nice to have come to Arunachal and hear Mr. Patil. Mr. Patil, if you are can't argue, so if you want to sit and argue, no problem with this.
No.
Initially, the case was registered under POCSO Act.
Some of you have your instructions.
Yes, my lord.
You are appearing as
Additional Advocate General.
additional advocate.
Yes.
Heard, Mr.
W. Wangsa.
W. Wangsa, learned counsel for the petitioner. Also heard Mr. M. Kato, learned DYSGI. And
For respondent number one only.
learned additional advocate general appearing the state response. So, considering the nature of the issue, considering the issue arising in the present petition, the learned counsel representing the respondents are directed to complete their instructions on the matter and apprise this court on the next date of listing as to the stand of the respondents with regard to the claim made by the petitioner in the present petition. When can you, at the earliest?
Next week. Next week.
Registry to list this matter again on 12th would be fine. 12.
Yes, ma'am.
12, 8.
Yes. Nice.
Just get that.
Yes, ma'am.
Small girl, she wants to go out also in the country for education purpose. She is a naturalized. Her grandfather was a naturalized citizen.
Yes, I have seen the
She was born before 1986.
Yes.
Just have it.
Ideal by obliged.
Item number 2.
Yes, Mr. Rama.
Yes, Lordship, this matter is with regard to this appointment of HGB, head Gauhati Lordship. This is there is a recommendation that is included in this writ petition. As per this recommendation, page number 80, this HGB of this Kaying
You Bajar.
Bajar.
are a Gaumbura, he is a Gaumbura.
Yes.
You say that because there was no selection as contemplated under the guidelines.
Yes.
21, 25 guidelines. So this is not permissible.
Yeah, not
But I think the appointments have taken place.
not yet to be appointed. This is just approval
When
has
you
been.
said that he is not appointed.
This is 20 as per the RTA information. RTA
Where did you, in your writ petition, say that the appointment order has not materialized? Only the approval has come.
we have I have clearly stated that we have filed RTA.
No, tell me, where is your statement to that?
Let me.
But Mr. We'll issue a notice, also the interim prayer. On the next date, we'll consider that. You, sir, we'll see. No, ma'am.
Lordship, this consequential order, if any lordship, that may be suspended lordship.
No. We can't, because if it is already appointed, we don't want to disturb that appointment.
This
Because
is
we don't know.
second March 2020.
This is because
probable.
2026. And
Yes.
you say the He is having political backing, so it automatically would have materialized. We'll see in the next day.
On next date, Lordship, hearing over the interim. Short date may be given, Lordship, after week.
You can serve him Dusty.
Yes, Dusty service.
Okay. But Mr. T. Tapakulan, counsel for the petitioner. Also heard Ms. G. Learned additional comment, senior government advocate.
For 1, 2, 3, and 4.
The petitioner in the present petition has the same. The recommendation made in favor of the respondent number 6 for his appointment as head Gaon Bura of Kain Bozar village, under Kain circle, revenue circle. First of issue notice returnable 4 weeks. There is another one, respond number 5, you made him a part.
Lordship, in case there is no interim order, Lordship, it will be infructuous, Lordship.
No, I'm making the prior interim order returnable.
In case of appointment, Lordship.
Whatever it is, interim order is made returnable, that's all. Because there is respond number 5, you cannot go and serve him by Dusty. Ms. accepts notice on behalf of respond number 1, 2, 3, and 4. No formal notice, extra requisite extra copy. Petitioner to take steps for service of notice upon respond number 5 and 6 by speed post, steps within 3 days. Petitioner is also permitted to effect service of notice upon respond number 5 and 6 by way of Dusty mode, routed through the registry of this court. Also, in the event the service of notice is effected on respond number 5 and 6 by way of Dusty mode, petitioner to file an affidavit to be set effect after effecting such service. Issue notice on the prayer for interim relief, also returnable on Two 9/2026. Issue notice returnable on 2/9.
Lordship, before that, any date, Lordship.
Difficult because you will have to, because respond number 5 is there, you'll have to serve him also, no?
But not on that first week of that September, because that is a saloon on that particular week.
So when should I put it? After that, 7?
7.
7/9/2026.
Item number 3.
Go to 7/9. Registry to list this matter again on 7/9.
May it please, Your Lordship. This is a seniority issue, my lord. My lord, we were given officiating promotion to the post of sub-inspector in 2019, along with the pay of sub-inspectors against available vacancies. My lord.
Then you came here.
My lord, we came here.
Earlier, then there was a regular selection.
My lord.
Promotion with respect from 23. Now, the division bench gave you a opening.
My lord.
That the order of your
my lord, from
where is that order? Where is that
from page 78, my lord, division bench. Seniority and other retrospective benefits.
Read that last line.
Yes, my lord.
The paragraph. It is needless to say.
My lord. 78. Be that as it may, it is needless to say that if the appellants are aggrieved by any term and condition of their promotion, including seniority, retrospective benefit, they shall always be at liberty to approach the learned single judge in this regard. And in the event the petitioners approach, the order passed by the learned single judge shall not be an obstruction.
Now come to the
the promotion order.
No, the prayer.
My lord. Prayer, my lord, we are challenging, my lord, the speaking order by which our seniority has.
But you have not challenged your appointment.
My lord, the promotion order, my lord, it is, my lord, it is with effect to.
That's it.
My
if
lord.
you have to have now a retrospective effect.
My lord.
Then because that promotion was not pursuant to a selection process.
It was a, it was pursuant to a DPC.
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 A regular DPC.
Regular DPC.
It was promoted.
Yes, my lord.
Then you got to challenge it to that extent.
My lord,
Because this order is very clear.
my lord,
Benefits under that order.
under that
We'll have
order.
to hear it.
My lord,
So if that order is not touched by me,
my lord.
how can I give you a retrospect? So that has attained finality.
My lord, that order in that event, my lord, the consequence would be the seniority of that order.
No, we'll have to. deem
The
promotion
genesis.
To be
My lord,
from the date of your officiating appointment. You
My
have
lord.
some service.
my lord,
It should be from that date.
my lord,
Now,
my
if
lord,
I don't touch that, get to touch that order,
my lord,
how can I give you a retrospective effect? Your effect, that promotion of 23
my lord,
by itself will not give you from 19.
my lord, my lord,
We'll have to deem that
My
this
lord.
promotion is from 2023.
my lord,
Premchand and
Ah.
all those cases would come.
my lord,
For that,
My
I'll
lord.
have to have
Uh,
touched that order.
touch that
Because
order.
this
My lord,
paragraph,
my lord,
by any terms and condition of their promotion, including seniority, retrospective benefit.
my lord,
So even if you don't get the salary,
My
at
lord.
least even for the purpose of seniority,
my lord,
I'll have to touch it. This would be a stumbling block for you.
my lord, my lord. But in
But
that,
we'll
my-
issue notice.
my
no
lord,
problem, but
my lord,
take steps.
my lord,
Heard
my lord.
PD Learned Council for the petition. Also heard Mr. Basar, learned junior government advocate, appearing for the state response.
1 to 4.
Issue notice returnable 4 weeks. Post. Ms. Basar accepts notice on behalf of respondent number 1 to 4. No formal steps, huh? No formal, so and so, so and so. Requisite extra copies. Petitioner to take steps for service of notice upon respondent number 5 to
My lord, 5 to 96.
96 by a registered post steps within 3 working days from today. Registry to this after 4 weeks on a date to be class. What is this additional affidavit for?
My lord, the office memorandum, my lord, by which the relaxation of 5 years was granted, and the recruitment rules amendment was proposed. My lord, my lord, my lord, my lord. Mr. Techi Toku is there with me. Mr. Techi Toku.
Mr. P.D. Nair, learned senior counsel, assisted by Mr. T. Toko.
Deeply.
TOPU.
TOPU.
TOPU, huh? Toko.
Item number 4.
Deeply.
Yes.
May I please, my lord? My lord,
What is the minimum period of service required as a contingent for being regularized?
your lordship,
There was a scheme somewhere.
there is a scheme, my lord, but that is not, I think, applicable. Your lordship rightly remembered, my lord. I just have found it, one recruitment rule. It is promotion. What your lordship is referring to is, it is the one your lordship is referring to, your lordship. That is the recruitment rule for the driver, your lordship. Your lordship may go direct to the schedule in second page. Item number 11, your lordship. Method of recruitment. 75% direct recruitment.
There is no post of driver in your institution.
No post, my lord. No post, my lord. But I have been serving it diligently and continuously since last 15 years, my lord. And department has in some instances, my lord, department has tried to put this proposal for this creation, my lord. But that has not been again pursued, my lord. So, your lordship, my prayer may be this. My limited prayer may be considered today, my lord. If my issues, prayer number 1 and 2 is considered for this stage, my lord. Prayer number 1 and 2 is considered, my lord. It will be adequate for me at this stage, my lord.
Otherwise, no post of driver, your lordship.
No, but if you are utilizing the services of a driver,
Yes.
that would be a forced labor then. If you don't have a post, don't have a driver. If you want a driver, create a post. Why is the post not created? These are useful members of a service. Without them, the office cannot function.
He has been appointed as skilled contingency, Your Lordship.
Skill, that is driver.
Yes, but not as a driver, but he's
But
being
his
used as.
services
Yes.
are, from here, it seems that his services are being utilized as a driver.
Yes.
Contingency driver, page 13, I found. There are 2 drivers. How long is the other person working?
He is also working for more than 10 years, my lord, but he is junior than me.
Yes, your name?
T. Jamo, my
Jamo, learned T. Jam, learned counsel for the petition. Also heard Ms. Pasar, learned junior government appearing for the state respondents. So, the petitioner, by way of instituting the present petition, has prayed for a direction upon the respondent authorities for a due consideration of the contentions raised by the petitioner in his representations dated 18/9/24 and 4/5/2026. The petitioner has also prayed for a direction upon the respondent authorities for creation of adequate numbers of posts of driver in the organization wherein the petitioner is presently serving as a contingency driver, and for consideration of his case against one of such posts so created. The petitioner has projected that he was when were you appointed?
Your Lordship, page number 12, 30/2012, my lord, 37/2012.
The petitioner, vide an order dated 37/2012, was engaged as a skilled contingency worker with effect from 1/8/2012 in the Department of Tirap and Changlang Affairs Command, Government of Arunachal Pradesh. It is projected that the petition on his such engagement was discharging the duties of a driver in the said establishment. The said projection is sought to be established via an order dated 5/1/2026, wherein the petitioner was attached as the contingency driver with the secretary cum director of the department. So the petitioner has further projected that he had completed around 15 years of service as a contingency driver in the department. However, on account of absence of a regular post of driver not being created for the department, the services of the petitioner could not be considered for regularization. The petitioner submits that raising the said grievance, he has already approached the respondent authorities by way of an appeal public representation dated 18/9/2024 and 4/5/2026, and the same are pending disposal. Also, the learned counsel for the petitioner has submitted that the departmental authorities had also placed before the competent authority proposals for creation of posts of driver in the organization, and the said proposals are also pending consideration of the respondent authorities. The learned counsel accordingly submits that a direction be issued to the respondent authority, that is to be issued to the respondent authorities, more particularly who should be the authority?
Your Lordship, one.
The secretary.
Yes, and
Department of Tirap, Changlang, and Longding Affairs.
Your Lordship, 3 will also be necessary, Your Lordship.
Longding Affairs.
One.
to consider the representations dated 18/9/2024 and 4/5/2026 submitted by the petitioner. I also recommend the proposal submitted by the, it's a director, Department of Tirap, Changlang and Longding Affairs, Government of Arunachal Pradesh for creation of posts of driver in the directorate. Ms. Ete submits, Ms. Basak submits that she would have no objection in the event this court accepts the prayer made by the learned counsel for the petition. So, in view of the consensus reached in the matter by the learned counsel for the parties, this court directs the secretary, Directorate of Tirap, Changlang and Longding Affairs, Government of Arunachal Pradesh, to consider the representations dated 18/9/2024 and 4/5/2026 submitted by the petitioner and dispose of the same by way of a speaking order. While it is further provided that while disposing of the said representations, the secretary shall also consider the fact that there is no post of driver created in the Directorate of Tirap, Department of so and so, and proposals in this connection are also pending consideration of the government. So, the speaking order be so issued within a period of 2 months. Within a period of 2 months from the date of receipt of a representation, receipt of a certified copy of this order along with a representation from the petitioner. With the above observations and directions, the present petition stands disposed. Issue a speaking order and communicate it to the petitioner. Yes.
Item number 5.
May I plead your lordship? My lord, this a common notification, my lord, was issued by the respondent one, my lord, whereby 8 occupants of government quarters, my lord, they were directed to vacate their respective quarter within 15 days on the plea that government structure will be built up, my lord. So out of these 8 occupants, my lord, 5 of them approached this honorable court with a very limited prayer that they should be given adequate time to vacate. And out of the remaining 3, my lord, these 2 of them, including the petitioner, my lord, they restrained on the plea that this quarter was in question was under dilapidated condition, and they have made it fit for habitation by themselves by incurring huge amount. So they should be allowed to stay there till superannuation from service.
Why superannuation? You should be allotted that permanently.
Yeah. And lordship, and the remaining one, my lord, the occupant of quarter number 503, my lord, he has been allotted, my lord, that portion of quarter, my lord.
Where is that order?
Oh, the allotment order is, my lord, as from page, my lord, 60 onward, my lord.
No, this allotment is of which year?
2016, my lord. 16.
You were also allotted before that.
No, my lord, ours is a allotment for timing only. But he has been...
Fine, whatever has been happened. But you say that you are occupying a government quarter.
Yes, ma'am.
Now, you have around 10 years of service, around about 10 years of service left.
Yes.
This quarter is according to the government, not fit for some reason.
Yeah.
They want to demolish the thing, build up a new structure so that more government employees can be accommodated.
Yes.
The others who came up before this court said, give us some time to vacate, we will vacate.
Yes.
This court permitted and accordingly they have vacated.
Yes.
Now you say, no, I'll have to be here. Give me till my superannuation because I have repaired that
Yeah.
house.
Yeah.
Two things. What is your right to claim that? Two, where is the order permitting you to rectify or maintain that quarter?
My lord,
Where is that order? And see, Mr. Counsel, they are asking you to move, giving you two options. Either you draw HRA
yes.
or we give you alternative accommodation. Your interest is protected.
My lord, even this 5, my lord, who sought.
I'm not concerned with 5. And there you had approached this court earlier.
Yes, ma'am.
See, 7 and 8 at page 35.
Yeah.
There is a conclusion already drawn that you don't have any right.
Yeah.
And you have not gone up on appeal against that.
But my lord, against the disposal order, my lord,
But there is, that disposal was, the considered view that the petitioners cannot be said to have a right to remain in view of the decision so-and-so, 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 the petitioner still residing. Now, you continue to reside, we will ask them to suspend you, drop departmental proceedings. This cannot be permitted. You are acting against a government policy. You are just a government servant. Once the government has said that we will do something here, you are stopping up. Implementation of a government policy will not permit you. And who permitted you to? That's not your property.
Yeah.
That's the property of the government. Who permitted you to make alterations, constructions, maintenance? Who permitted you? And where is the material to show that you have done it?
My lord, we have applied through RTI some materials, my lord, relating to.
We are not. If you want some time, reasonable time to shift, tell me, I will provide for that. Otherwise, yes, Mr.
Lordship, that cannot be also. This is third round of litigation. Second round, Lordship, they have stated that they are withdrawing, but this order was passed on 27, this last July 27. Lordship. Only 1 week was on.
It is not annexed. I think it is annexed.
Yes,
No,
withdrawal order we have annexed.
That order is not annexed, Lordship.
Because
27-7.
in the earlier writ petition, it was defective, my lord. Some vital documents were not
No,
annexed.
but
my
then that order was passed. On that day, they were asked to withdraw, but they didn't, Lordship.
No.
Only 1 week time was allowed. Another 1 week.
Most reasonable order. Yes. We are not going beyond this.
Only for these 2 quarters, Lordship, this two
whole project
petitioners,
is-
Lordship.
You
The
want-
work is halted now.
I'm still telling you, if you want some time, reasonable time to move out, I'm giving you, or I'm rejecting your interim side.
Lordship, in that case, we may be given adequate time of 1 month, my lord, because we have children.
month?
Yes.
1 month.
Yeah. Because we have children.
Time was allowed, Lordship. And work is halted, Lordship. Work has started already. Building
Okay,
is,
we give him 15 days time. 15 days.
Lordship.
Lordship, we have school-going children also, so 1 month may be kindly given.
That was spread in the first round of
This was
litigation,
on
Lordship.
27/7, you got that order.
Lordship, these 2 are not budging only, Lordship.
But we are
Department is
seeking.
trying every.
And if they're not budging, you're not left with or without alternatives. You have that 11 route, the Public Premises Eviction Act.
Lordship, this
You
was.
can also initiate departmental proceedings, place them under suspend, and impose penalty. There are ways and means to control, manage your employees.
I am praying for cost, Lordship, in fact,
You
because
can-
this is
Suspension,
on the same
50%
issue.
salary, penal rent
Yes,
from the date when he was to vacate, he did not vacate, and departmental proceeding, which will be a penalty.
But my lord, no courtship action has been initiated against this occupant number 5. He has demolished the whole quarter, my lord, and constructed private.
Lordship, this third party was never there in the first and second round of litigation. Just an
He have
excuse,
constructed
Lordship,
private
this is-
building, my lord, but no action. He's equally a government employee, my lord. That is our contention. Man. No fairity, man. Pick and choose policy, man.
Show me your right. Show me your right. Show me the prejudice. You have been given an HRA or you are given alternative accommodation. You have not said anything on that.
And even in the building also, they will be given first priority.
That is also there.
In a flat, it will be given to them in the first priority.
We are dismissing it, giving you 15 days time to vacate. If not, any coercive action as may be taken by the government or forceful eviction, they will do.
My lord, 1 month instead of 15.
15.
No, 15 days. Also.
You had
Already
enough.
1 week has been given also.
Your conduct does not move this court to give you further relief.
Our only contention.
5 and 7 dismissed. Disposed of. Yes.
Lordship, our only contention is that although he is equally occupant, this occupant number 5,
Counsel, first establish your right. Then we will see what 5 is there. That madam will take care.
Okay, ma'am.
Mighty state will take care. This court need not come in. Can you tell me of your right? If you have a right, tell me, I'll consider. You don't have any right. Sorry. Can't help it. Disposed of. What did you do?
Obliged.
Obliged.
5 and 7, huh? Same.
This
This minute chamber. No, that both have gone. Election matter, both have gone. Both, then I'll take up that Gauhati matter.
Item number 6.
May I please, Your Lordship? Lordship, I'm aggrieved by impugned order dated 1/5/2025, whereby my name has been deleted from the employee of RD, District Rural Development Agency.
You were a DRDA employee.
DRD employed. I was absorbed in RD department by the
Pension also.
pension also.
What is the reason? No reason.
No reason has been assigned.
Yes, my lord. As per my instruction, my lord, there was a committee, my lord. Committee was constituted. My lord, before there, my lord, they were DRDA employees, my lord. Now what happened, my lord, during the process of absorption, my lord, they have retired, my lord. Now when the order of absorption was passed by the state government, my lord, they had already retired, my lord.
When was the decision to absorb?
My lord, actually, I wanted to know when they have superannuated, my lord. There is no mention when they have superannuated.
No, forget it. Where is your order of absorption?
Absorption, my lord.
Absorption order may kindly come to page number 27. Your Lordship, this notification was issued in pursuance of order dated 1/11/2021 by the Ministry of Rural Development.
Page 27, my lord, annexure 2 is here.
Okay. When did you retire?
So I was retired in the year 2023. But this notification was issued in pursuance of notification dated 1/11/2021. So accordingly, I was drawing monthly.
There were mistakes in the order dated 22 to 24, my lord. So page 30 there was some mistakes, my lord.
So your case is that on the date when this order was passed, they were not in service.
Yes, they were not in service.
Your name?
M. Kamcham.
M. Kamcham.
M. Kamcham.
Learned Counsel for the petition. Also heard Mr. Who is appearing for this central government?
Your Lordship, may kindly.
Mr. Pichai, you are appearing for whom?
I am for, my lord, 3 and 4, my lord. Secretary RD, Standing Council RD, my lord.
1.
Hello there.
Oh.
I'm appearing on behalf of Martha.
We'll try. He's here. Mr. Kato is here. Heard Mr. M. Kato, learned DSGI,
May I please, Your Honor?
R. Basar, learned junior government advocate. I'm not dismissing it, I'm issuing a notice only. Also heard Mr. B. Picha, learned standing counsel, rural development department. Issue notice returnable 4 weeks. Mr. Kato accepts notice on behalf of respondent number 1. Yes. Basar accepts notice on behalf of respondent number 2,
5, 6,
5, 6, 7, and 8. Also. And Mr. Picha B. Picha accepts notice on behalf of respondent number 3 and 4.
Yes, ma'am.
As all the respondents are represented, no formal notice is to be issued. Also. On the Baki requisite copies are on the next date of listing, Mr. Picha shall apprise this court as to why the names of the petitioners after being as to why all the petitioners have retired.
All the petitioners. Yes, ma'am. Your Lordship may kindly take note of petitioner number 1. He is a regular
He's
employee.
working, still working.
Not working.
All have retired
All are, yeah.
and all were given pension.
Pension, yes.
As to why the petitioners, after being authorized pension oblique family pension, comma, were subsequently as to why the pension and oblique family pension authorized to the petitioners were subsequently withheld. Also, wait, just give that reason.
Yes, ma'am.
Obliged. The registry to list this matter again after 4 weeks.
Obliged.
Principal seat matter, item number 1.
In this case, Lordship, we have filed the affidavit yesterday.
That has been transmitted to me. Yes, Mr. Das.
Milord, so far as the affidavit is concerned, Milord, I have nothing to say. They have annexed the 2 NOCs granted to the 2 of the officers, Milord, page 351 and 352. My submission is that since those officers were already, Milord, granted NOC with some certain conditions, Milord, my submission would be that same conditions may be imposed in my case also. And, my lord, I am entitled for the NOC, my lord. That is precisely my case.
Okay. So, Mr. Das, what I have got reading is 352 is that they have not been granted a leave. They have been granted a permission. They have not been granted a leave.
Yes.
And they have been asked to do all the works that are to be done.
Whatever stipulation is there in 351 and 352 may be incorporated in my case also.
Let us see the practical aspect. You have to undergo 6 months of
not on that, my lord. It may so happen that I may have to submit an application before the Tezpur University, either to relax or.
But your whole case is built up on that you have to undergo 6 months.
My specific prayer in the writ petition in number 2, prayer number 2 is that to grant me NOC, my lord. Rest, my lord, what happens, whether study leave is given or not, whether the petitioner makes an application for UL, whether the Tezpur University relaxes that, my lord, I am not going into that aspect of the matter, my lord.
Okay. Anything more?
That is
Anything
only
more?
one small prayer, my lord. If this honorable court, my lord, comes to the rescue of the petitioner, in that event, my lord, perhaps there will be requirement of passing some order to the Tezpur University.
If we cross that bridge, then we will also pass orders to the Tezpur University, because this is nothing a big thing to accommodate you.
Exactly, Milord.
But that will be if when we come to that stage. If we come to that stage.
That is why, Milord, I have submitted that if.
Mr. Chaudhary, Mr. Chaudhary, this program that you have part-time also would require a 6 months in-course service, work in the university campus itself. Okay. Yes, Mr. Second.
So there are two parts. One part is the permission to pursue the course. And he has later on tried to build up the case that there is a violation of Article 14 and brought some instances and 2 or 3 persons were named. So in response to that, we have given the NOCs or the permissions which we have annexed. I would like to read out this at page 351.
So yeah, we have gone through it. We have.
Let me place my arguments on that. So what it has been said on 10/7/2025 with reference to his application dated so and so, the competent authority
Just see what has happened. That's stuck.
to grant permission to Sunyam from Kaziranga University.
Suraj.
Lordship, my laptop is getting disconnected, so I'm calling from another one. So next person. Hello. Am I audible?
I'm hearing you. Yeah.
Study courses should be pursued before and after normal working hour of the office and holidays. That is 2. Number 3, if at any stage it is found that Sri Sunil Kumar Bonia has been neglecting his duties for sake of his studies, the permission shall be withdrawn at any moment without assigning any reasons besides inviting disciplinary action. And lastly, the permission shall not entitle Bonia to claim leave either for preparation or for duration of the examination, and that leave, if any, required for the purpose will be sanctioned subject to its admissibility and administrative interest in terms of the relevant rules of the institute. So these are the conditions which are very clearly laid down in the permissions. So his case cannot be equated with the 3 cases which he has cited by also in saying that there is a violation of Article 14. That is one part, because the conditions granted for pursuing those courses were totally different from what has been requested here. During the course of the deliberations between the writ petitioner and the authorities, he was asked to give us the details regarding his course, tenure and all. He refrained from giving response, and on the other hand, the institute wrote directly to Tezpur University said that 6 months he should be stationed in Tezpur campus to pursue the 3 years PhD course. So we cannot equate both the courses and both the permission in the same level. Now coming to paragraph 15, how he has ignored his work, neglected his work, and what is going on and why he is required in the institution, that also I would like to pursue. Please.
Paragraph 15 of your additional
Paragraph
affidavit.
15, 325 of my reply.
Yes.
These official records are not relied upon as fresh reasons in support of the impugned communication dated 26/8/2025, but merely to demonstrate the continuing nature of petitioner's official responsibilities and negate the allegations of malafide and afterthoughts raised in the affidavit in reply. The following major works may be referred to. There are 2 components. One is repair work, and the other part is phase 2 of the construction of the guest house, the doctor's clinic, the administrative building, and then the store of the university. Central store. So may I read it?
Where do I get this?
I'll go because I'll place it. Then Lordship will come to know. The said file was examined at various levels. Upon consideration of the issues raised therein, the competent authority vide note 12 dated 21/5/2025 directed the matter to be put up for discussion with all the officers concerned. Thereafter, vide note 15 dated 23/5/2025, the file was returned to the petitioner with the directions for necessary action. The said directions required consequential actions on the part of the petitioner for convening the discussion with the concerned officers and for further processing the proposal before the competent authority. Next page. However, while the matter remained pending without action on his part, the petitioner submitted an application dated 10th of July 2025 seeking issuance of a no objection certificate to pursue a PhD program. The sequence of events demonstrate that while the petitioner is pursuing his personal academic interests, he failed to accord due priority to the official work entrusted to him. In view of the continued pendency, the petitioner was called upon through an official email dated 6/3/2026 to explain the reasons for the delay, the non-convening of the meeting, the failure to process the file, the failure to report any difficulty to the competent authority, reminder communications dated 12/3/2026, 13/3/2026, 16/3/2026, 18/3/2026 were also issued requesting him to furnish his explanation. The petitioner neither submitted the explanation sought nor completed the assigned works. Relevant documents are annexed. Next, Lordship will come. This is regarding the repair work. Now coming to the expression of interest was to be floated about a year, more than a year ago. Till now, that expression of interest has not been finalized by this gentleman. B. Preparation of expression of interest for phase 2 of construction works in e-file number so and so. The file discloses that vide note dated 7 dated 4/11/2025, the petitioner was directed to prepare the expression of interest for the proposed phase 2 construction work. Despite the lapse of several months, the work remained incomplete. Till date, it is remaining incomplete. Subsequently, by note 14/8/5/2026, the petitioner himself recorded that the work for preparation of basic structure of EOI is in progress. However, EOI is yet to be finalized and cannot be published without finalization and approval of the estimate. The record therefore demonstrates that despite repeated opportunities, the assigned work relating to preparation of the EOI has not been completed by the petitioner. All the note sheets we have annexed. The above instances are only illustrative and not exhaustive. There exist other official assignments entrusted to the petitioner that also remain pending and were not completed. Owing to constraint of relevance and brevity, they are not being set out in details. So what more is required, Lordship? He is neglecting his work is pending.
You referred to this note wherein that,
yes.
Where exactly is that note?
Yes, Lordship will kindly come to. I'll place all the notes. Page 345.
That relevant note.
Every relevant portion is given there. Lordship may be pleased to pay those. I will place everything.
Just highlight that only.
Then Lordship will kindly come to page 345, note number 7.
14.
Page 345, note number 7. Receive the estimate, the same will be reviewed. Similar exercise may be done for building like central store, cafeteria extension, academic block, director's office, and total site development of the area. Previously to that, as desired in the please find here with the estimate contain the scope mentioned in above. Now, estimate has been prepared as per so. Then it was incomplete. Note number 6 and 7, if Lordship is pleased to see, note number 6 is given by the read petitioner. Then the response from the authority that it is he has yet to file. Page 345. Sorry. 345 page number.
I got it.
Then Lordship will kindly come to page 346. Then estimated as desired, please find attach the estimate containing the additional scope as mentioned above. It is not estimate with additional scope. Soumitra Adhikari's signature 31/2026. This was after how many days? This was after 2 months. He gave this note. Then note number 9. The following details as specified below at serial number 1 to 9. The information to each query may be provided in specific and technical terms and must be devoid of any evasive or circumstance to any writings. Number 1, whether the component of forest royalty, which is a statutory and mandatory requirement, was taken while preparing the estimate. If not, the reasons thereof. 9 queries were raised here. The reply must be given latest by 2026. Then Lordship will find his response. Based on the deliberation and justification, revised estimate of 60 crores is hereby submitted for your perusal and necessary approval. Copies of the email regarding deliberations and so, it has been given on. It was given the 20th February was the last date. He gave it on 7th of April. Then that was also not complete. Lordship will kindly now come to 11. I am reading the the blocked one at the 3rd paragraph. Clear, complete, point was technically reasoned and fully documented, supported reply to each and every query may be furnished to the queries along with signed final estimate. This process is still there going on, Lordship. It is still continuing. Nothing has been concretized. After 2.5 months, he responded when 1 week's time was given. Then Lordship will kindly come next page, chronological transcript noting. Then 12 also it has been his. Last paragraph, further it is proposed that if the submitted replies are still found to be unsatisfactory and unacceptable, despite submission of multiple repeated justification and clarification, then opinion have to be sought and discussion and consultation with technical organizations like CPWD. He suggested that he cannot give it, use consult with CPWD. That was on 27th of April. Now next, note 13. White note dated 24/4/2026. Clear directions were given to furnish a complete point-wise and document-supported reply in e-office file. The reply submitted white note 12 of 27/4/2026 and attachment has been examined and observed that the reply does not address the queries in a structured, point-wise and technically substantiated manner. The key issues relating to variation in estimates, forest royalty, GST methodology, compliance with scope instruction, and mandatory components remains unresolved. Also, the required supporting documents and calculation details have not been furnished point-wise as directed. Further, the direction issued by note number 7 dated 4/11/2025 regarding preparation of EOI remains incomplete till date. Accordingly, the reply number 12 recorded a non-compliance of the directions issued in note number 11. Without the above requested clarity, it would be difficult to proceed further. As regard any requirement of third-party vetting, the same can be envisioned only when clarity exists regarding our viewpoint and calculations, which remains opaque due to non-reply to the queries despite being directed. An extended timeline to 8 May 2026 is given to submit the following: complete, point-wise and document-supported reply to the final specific queries in respect of the estimates of SBLLM relating to phase 2 construction work. Submit the expression of interest document at the same. Then 14th, it is his response. Sincere effort has been made by multiple times to address the queries and several justification clarification have been already submitted against the short queries. However, justification and clarification submitted by the undersigned are still found to be unsatisfactory. Hence, it is once again proposed that opinion, discussion and consultation with technical representative CPW may be done by the undersigned for an early resolution and closure of the matter. It is to clarify that the proposal for discussion and deliberation is not for third-party vetting, but solely for resolution and closure of the matter as per the opinion, etc., obtained during the consultation and discussion. Also, it is to be noted that a similar approach of holding discussion for obtaining opinion, clarification, and consultation with technical representative CPWD was adopted earlier by the Institute for Resolution and Closure of the Matter, involving queries regarding an estimate prepared and submitted for approval. Here, he has not given the estimate also. That is the problem. Also, the work on preparation of basic structure of EOI is in progress. However, EOI is yet to be finalized, cannot be published without finalization and approval of the estimate. It is his duty to prepare the estimate, his duty to prepare the EOI. Till now, that
So
tender
this
has
is
not been,
projected.
till now the tender
Mr.
has not
Saikia,
been,
this is project.
EOI has not been
This is
floated.
projected. This is projected to show that he has some pending work in your organization.
Pending work, and if suppose EOI is announced, it is published, then immediately we have to get the bids and we have to verify and allot the work, and thereafter work has to get started.
And how is the petitioner involved in that? He is the one who has to do.
It is his duty. Third party will be doing, it will be given to some contractors, but monitoring, day-to-day monitoring have to be done. Whether as per the drawing, as per the estimate, as per the requirement, technical specifications, all supervision, all monitoring work he has to do. That is why his request was rejected for the time being. And this work is pending for last 1.5 years. So this
Anything
is my
more, Mr. Singh?
submission. The law is well settled, but I am arguing my case basically on facts.
This is a case on facts, basically.
This is a case of facts. And regarding the law also, in our written arguments, I have given all the judgments and the various propositions of law. This is my humble submission, Lordship. I may be allowed to leave now. My part is over.
Mr. Das, Mr. Das, anything more left from your side?
Not only one submission, page 350, note number 14. And second last paragraph is the answer to all the Milord note.
Okay.
That is my Milord.
Mr. Chaudhary, you want to make any submission? You have nothing to say. You are enjoying the show.
My role will be coming only after
Mr. H.K. Das, Learned Senior Counsel, assisted by Ms. D. Mohanta. Also heard Mr. E. Saikia, Learned Senior Counsel, assisted by Dr. A. Chomuha and Mr. R.K.D. Chaudhary, Learned Senior Counsel, DYSGI, assisted by Ms. L. Devi. Hearing concluded. Register to list this matter on Friday at 2 p.m. for delivery of judgment.
Highly obliged.
Friday.
Item number 9.
Custom to this.
Yes, I'm looking at you.
May I please, Your Lordship?
Okay. Yes, Mr. Ringo.
Sports quota, my lord. My lord, may I first come to page 49.
Give me a bit background of the facts.
My lord, this is for appointment of junior engineer in UD department.
That same matter, Ratan, that day we were hearing.
No,
this is
my lord, that was for constables. This is for junior engineer.
Junior engineer UD department.
Urban development.
Yes. There is a memorandum 1995 in which there is a hierarchy of how the preference should be given.
Where is the advertisement?
Advertisement, my lord.
I'm sorry, I'm troubling you with the facts. Normally I don't, but yesterday I could not read it. I was with the other files. Yes. Advertisement?
No, let's see.
Where is the advertisement, Mr. Abhi?
Sorry, Lordship. Starting the case from backward, so I'm finding it difficult now. I'm starting the case from backwards, so I'm finding it difficult now.
Backwards means?
Starting with the memorandum itself.
No, you come to the advertisement.
Lordship, this is
28.
yes, Lordship.
Yes.
This is for
And this is the advertisement you are agreed with?
no, I'm not agree with
No,
it.
means,
Yes.
the issue is starts from this advertisement.
Yes, Lordship. Two posts, junior engineer.
Hmm.
This is 26 November 2021.
Hmm.
Then the
Meritorious sportsman.
meritorious, this is called MSP, meritorious sports person.
Hmm.
Requirement is meritorious sports person.
Hmm.
From reserve, the post is group B, non-gazetted,
Hmm.
reserved for APST,
Hmm.
scheduled tribe.
Hmm.
Then Lordship,
You are
the
an APST.
yes, that is not in dispute. The documents required is class 10 pass, certificate and mark sheets, then degree and diploma, degree or diploma in civil engineering, then certificates on representation of competition duly signed by competent authority of sports as listed below. Then the form is also given at page 59. Then on 26 May 22, there was an addendum in which it is given, may I read, Lordship? White in the advertisement floated white UDH 10-2611, yes, for recruitment to the two posts of junior engineer for meritorious sports person. The mode of selection was to be kept as per the terms of OM number dated so and so, dated 18/7/2001, whereas the mode of selection should have been part of the latest OM, that is 2nd September 2020. So therefore, candidates who possess criteria as per OM 2020 dated 2nd September on or before 2021 may apply from 6 June 2022 to 20 June 2022. Those who have already applied need not apply again. So, Lordship, there was we applied, petitioner is qualified. His testimonials are at page 24 to 25 onwards, 24 and 25. Then thereafter, there was a walk-in interview. Lordship may see page 61. Before that, Lordship, this is also part of the RTI because the documents were not furnished to me earlier. Page 98 is the shortlisted candidates. And Lordship will see in the last column, page 98, my name appears at page 99, serial number 3. Lordship will see these are the certificates which were taken into account.
90?
99. Starts from, this is the list.
Lucky.
Yes, Dolang Lucky.
34, senior tug of war, national war, so and so, so and so.
Senior, national, senior national, senior national. First is silver, bronze, and silver. Then these are the, what they do is we submit the certificates, then they check the certificates and they see which would be accepted by them. These are the list of the, so to say, accepted certificates. Then the name of the private respondent appears in page 100. Serial number 10. Lordship will see. Hers is in the fourth column, junior national, junior NSFGFI, Top Mania. Top Mania.
Top Mania, okay.
Yeah.
National Karate Championship.
Yes. Lordship will see it's, I'm specifically saying junior, junior national, junior NSGFI, senior journal, and senior journal. The medals are gold, gold and bronze.
Correct.
Yeah.
Individual item.
Yes, individual line. So these are
Phone number?
response number 5.
Then?
Then
So
Lordship,
you agreed by response number 5.
yes. Another one also, Lordship, but he has not appeared before. Lordship, his name is Bamang Ampa. He was shortlisted only. Lordship,
Page.
in this list of Lordship, Bamang Ampa.
Bamang Appa.
Yes.
103. His response number?
Response number 6.
So he is in senior national. Bush.
Yes.
Okay.
But he has not appeared.
No, fine.
Yes.
He appears, he doesn't appear.
Now, Lordship, what they do is after this certificates are given, they shortlist the candidates. This is what I have shown, the shortlisted candidates. Then there was a walk-in interview. Lordship, we'll see from page 61. This I also had to get through RTI. Sorry, Lordship, that walk-in interview would be at the page 88. This is part of the RTI. This is the minutes of walk-in interview. This
These
was
are the shortlisted candidates.
Yes. My name appears in serial number 2. May I read, Lordship? This was, it's important because the testimonials, they say, have been verified and found to be in order by the experts appointed by the Department of Sports.
So there is no dispute with regard to your testimony.
No. But I have a dispute regarding to her testimonials.
Okay, fine.
Yes. So here, Lordship, we'll see page 89. Is the, your Lordship will see some names here, page 89. Likha Lej.
No grievance against him.
No, he was the serial number 1. My Lordship, there were two posts. Second is Tapmania. She's the response number 5. Then response number 6 is the waitlisted candidate, Bamang Ampa. Response number, then serial number 2 is Dolang John, who had relinquished the post itself. He had relinquished the race.
He was appointed.
No. They are just waitlisted, Lordship.
So only appointment is Likhalej and
Tapmania.
Okay.
So, Lordship, page 90 is my representation. Page 91 is also my legal notice sent on my behalf.
Okay. What is your grievance with this recommendation?
My grievance is that, Lordship, this recommendation, this walk-in interview, the results of this walk-in interview is not in terms of the memorandum which is in force.
Okay. Now let us go to the memorandum.
Page 49.
Now the memorandum.
This is the memorandum which has been adopted by the state government. That is 2nd September 2020. This is 1995 memorandum. This has been adopted by the state government.
But this advertisement is of 21.
Yes.
And in 2020, they have adopted an office memorandum of the government 19/2020. Page 51.
Yes.
And that you will find that page 53. So
Yes.
that will be the one which will be holding the field.
No, Lordship. The 1 September 2020 has also, this is the, so to say, the mother memorandum. This has been adopted, Lordship. This is not disputed by them, Lordship.
Okay, read it. Go to.
Lordship may directly come to para 2. In order to facilitate proper selection of sportsperson, it has been decided that sportsperson who fulfill the eligibility conditions laid down in para 1 of this department OM dated 4880 referred to above shall be considered in the following order of preference. A, first preference to those candidates who have represented the country in international competition with the clearance of the Department of Youth Affairs and Sports. Next,
First preference is international.
yes, that we are not
Second
concerned with.
is senior or junior.
Senior or junior?
And if it is between a senior participant and a junior level participant, it will
The senior, it will be the senior.
the next would be in university
Yes,
and thereafter school.
yes.
Okay.
So your Lordship has seen, and also Lordship may like to see page 50, in the note number 2.
If there is a tie, then it will be by number of medals.
Yes. Note number 2, Lordship, because mine is tug of war, which is a no, which is a team event. No, it's therefore note number 2 would be important. Participation in participation in individual and team event item may be given the same preference. So I'm relying on this to say that the medals which were seen at page 98, page 99 and 100, it is very clear that even though I have my highest medal is silver, but still it is in a senior national. Hers is in junior national.
Because they don't make the distinction at the first instance on the medals.
Yes.
You have to be within the first 3 positions.
Yes. If it is the same, then there will be distinction in the medals.
Okay.
So this is my entire case. Now, Lordship, what they have done is they have, Lordship, initially they had filed some affidavits, Air Department, saying that we have simply followed the memorandum. Thereafter, it was pointed out by me when the hearing was done that the medals which were tallied by the sports department, it has to come into record. So therefore, the sports department had filed an affidavit. This affidavit, Lordship, in my copy, the date is not given, but it is an affidavit filed by the sports department, respondent number 2. In para 3,
Just a moment, just a moment. Why one tadarapa?
this is, yes.
Yes.
Earlier affidavits were not very clear, so this is the one that they have. This is clearer, I would say. Page 194, para 3 is the additional affidavit. As my Lordship found. In response,
Category gold medal.
junior category. This is the thing that they have said.
But that is evident from that list also.
Yes, but some, Lordship, some objections were raised when the hearing was going on, that there are some certificates of the respondent number 5, which was in senior category gold. which was not, which was part of the RTI documents which I have annexed. But the fact remains that I may give 10 certificates, 20 certificates, but it is the sports department who decides which one.
Why did the sports department, they'll have to also give an explanation as to why they have.
That lordship, they have not explained, therefore I have obtained copies of through RTI, which will make the matters more clear.
Okay.
So in reply to this lordship, I have filed an affidavit in reply, in which it is clear why those documents were rejected. Lordship will see the affidavit filed by me, affidavit in reply to the additional affidavit filed by respondent number 2. Lordship will see I had filed an RTI, page number 212. Minutes of meeting and para-wise note sheet file dated 2nd December 2025. Para-wise note details, name of board members constituted for re-verification, details of board members present and said, and minute of meeting, score sheet and medal tally for all the accepted candidates of MSP, for interview MSP JE. They have not.
Take me to the relevant thing you want to show.
Lordship, page 214. This is a copy of the board meeting which was conducted. It is very clear, Lordship, the last paragraph. The recommendation for candidates for appointment and waiting is prepared by the board constituted by so and so 21st September 23 during walk-in interview held on 11 October 23 at 11 hours in the office of the Commissioner Urban Affairs is not as per the score sheet and consolidated statement of shortlisted candidates prepared by the scrutiny board. So it seems that the walk-in interview, the minutes of which I had shown earlier.
What are they trying to highlight here?
They are saying that the sports department had prepared a score sheet, which was to be done by them only, of course. This was not taken into account.
No, they say that the recommendation of candidates is not as per the score sheet and consolidated statement of shortlisted candidate prepared by some other board, scrutiny board.
Scrutiny board, because there is a scrutiny board before, because it is conducted by the sports department, the scrutiny of the medals, of the achievements. That Lordship will find at page 222, Lordship. This is the score sheet prepared by the sports department. This was supposed to be followed. Lordship will find at serial number 3 is my name. Then Lordship will see in the columns, these are the scores given by them. My name.
That is the private response number 5 here.
Private response number 5 is serial number 10. As per the scores, it is not even second or third, it is 9th.
Okay. Then?
This was not followed according to them. Thereafter, Lordship, the second RTI, this is the total number of rejected candidates for JE MSP, total numbers of rejected applicant for karate for the post of JE MSP. Because the respondent number 5 is in the discipline of karate, there were some other candidates whose candidatures were rejected. So I asked for the list of the candidates rejected and why they were rejected. Now Lordship will find in the next page, the details of which are given in the page 2, 27. So serial number 1, Goda Dinu, Lordship will find in the column, in the fourth column from the right, that his candidature was rejected because it was All India Wadokai Karate Association. This is because it is a style which is not recognized.
You mean to say the respondent number 5 also went?
Yes, yes.
Where do
What they were referring to, Lordship, are in the earlier, that is why I had said that the sports department should file an affidavit. Although this was not in the affidavit filed by the state, nor was in the affidavit filed by the respondents, the official respondents, but they had harp upon this point that this is a part of the document given by the petitioner, but this is a part of the documents which were submitted by the respondent,
So where is this certificates of the private respondent?
This is, Lordship, page 61 onwards. 64, Lordship. 64, 65. 66 is a type copy. 67. 68. 70.
60.
Lordship, let us go one by one. This is the 65 is the certificate given by the Arunachal Karate Association. Then 67 is a certificate of Northeast Games, which is a zonal game. Then, Lordship, 60, the next page, 68.
State level.
Yes, state level. 69 also state level.
It's but something else.
Lordship?
It's some, not karate, it's Shotokan state level karate do champion. This is the same karate itself.
But a style, probably. Then 70.
Northeast.
This is also a zonal game. Then 71 is also a state level. This is in fact sub-junior, which is not even a junior, sub-junior in the category of sub-junior. Then 72.
This is a gold medal.
This is a gold medal, but it is not even a junior, it is a cadet. State says that it is a junior, but it is a, here it is mentioned cadet.
National Karate Championship.
Yes, and Lordship will see the category. It is not junior, not senior, it is cadet.
Oh, that means it.
Yes, it is even lower than junior.
School.
Then, Lordship, the one they were harping on, page 74. This is senior woman.
This is the certificate cancelled in respect of Gadu.
This is a certificate which was not taken into account.
With Gadu.
Yes. This is a gold senior, but this is a Lordship, Wadokai, which is style. And therefore, some other candidates I have shown by RTI, many of them were not accepted because this is a style.
Okay.
It is not just the respondent number 5.
Anything?
Only that, my lord. But before they begin, there is something I'd like to point out. The petitioner, your lordship will recall that the final selection process was done on 11/10/2023, the walk-in interview, the minutes of the walk-in interview. I was not selected. Thereafter, in the group C post, this is a group B post, this JE is a group B post. Thereafter, in the cadre of Group C post in another department, I had applied and I had been selected, and that is already mentioned in para 18 of my writ petition. That happened much later. I was even in the early part of December 2023, the advertisement was there. Final result was in 14/3/2024, and I was appointed in 10/6/2024.
Appointed as?
Forester is a Group C post. But this is after all these things took place, Lordship. They are raising this objection now, saying that I could not have been appointed. But I have filed an affidavit, additional affidavit in reply, saying that the respondent number.
Just one more thing.
Yes.
What is the validity of the select lists that are normally published in terms of these advertisements in the state?
Lordship, in that I don't have any idea,
When
Lordship.
was the select list in this case published?
Select list, Lordship, I do not have the select list. I only have the appointment order of the.
Where is that?
That appointment order, Lordship.
That lady's.
That lady's appointment order is at page 105, 11 November 2024.
11 November
2024.
and you immediately came.
Yes.
Okay. Yes, Mr. Rada. What is the basis?
Yes, my lord. My lord, I'll take your lordship to page 88 again.
88.
88. My lord, there were 24 candidates, my lord. And my lord will see in the next page 89. The first is litigant-in-person. The second is the private respondent. There are two waitlist candidates, my lord. Bamang Ampa and Dolang John. The present writ petitioner, he is not even in the waitlist.
So what is the basis of?
Yes, my lord, I'm coming to that. In the course of hearing, after the certificate which we find in the writ petition itself, at page 64, which my lord has also seen, that senior category, page 74. We were of the opinion that this certificate might have been missed out in the compilation. We then sought instruction from the department whether this certificate will be counted for assessing the sports quota. This can be included. Then our affidavit, we have filed that no, this is a style, this will not be, and therefore the private respondent's highest category of certificate will be national, senior national, junior national, as per the compilation. At page, my lord will say page 100 again. Her highest private respondents, highest sports certificate will be junior national.
100, huh?
And writ petitioners is at page 99, serial number 3, Dolang Lucky.
So she is a junior national gold. That will be the highest.
Yes. And this petitioner is serial number 3, Dolang Lucky. He has 4 medals, my lord. First is silver, 2 bronze, and then participate.
So last one is out of the way.
Yes, my lord.
First 3 will be taken.
Yes, my lord.
So it is senior national, his level.
Yes, my
Senior
lord.
national, silver.
Yes, my lord.
Okay.
My lord will also see at 101, the person who is in the wait list, Dolang John, he also has the same 4 medals, 4 certificates, 1 silver, 2 bronze, and then participate. Then My lord, we'll
It's
see.
also of the same sports as of the petition.
Yes, my lord. He is in the wait list and he is not before this honorable court. And the second wait list person is at 103, page 103, serial number 27.
The first waitlist.
Serial number Bamang Ampa, my lord, that's in.
Wushu,
Yes, my lord. And he also has
bronze, one.
yes, one bronze or rest participation. Now, as my learned friend also has shown in his in her affidavit in reply, what was the compilation and what should have been the ranking, my lord. My lord will kindly again look at page 222.
Hmm.
222, serial number 1 is the first. Then writ petitioners, serial number 3, C is the third. The private respondent, serial number 10, C is in the 9th rank. 9th. C is in serial number 10. C will be in the 9th rank in the remarks column.
Okay.
In the first one is the first serial number 1. Lika Lej is the
First. Okay.
first.
Nine.
Dolang Lucky, the writ petitioner,
Is third.
Third. And then serial number 20, Dolang John, who is in the wait list. He is in the 2nd rank.
Serial number 20.
Yes.
Okay, Dolang Jong, second.
And the person at serial number 27, Bamang Ampa, he is in the 8th rank.
Yes.
So, my lord, as per the memorandum and the preference that has to be given as per the memorandum, the appointment should have been as per this compilation. Now, we have also stated in our affidavit that yes, this by the sports department that we have compiled the certificates, but appointments have been given by the UD department. Now, the problem here is the person who is the Dolang John, who is in the wait list number 1, could have approached. He is not before this honorable court. Of course, the private respondent, her ranking is in the 9th rank. The petitioner is in the 3rd rank. Even the second wait list candidate, who is in the 8th rank, he is also not before this honorable court.
So even if we allow this writ petition, petitioner will not get it. It will be the second person in that sports department categorization who will be through.
Yes, my lord.
Got it. Then
And it is the petitioner's own submission that she is already into service in
material for this.
Yes, my lord. And here, rightly, wrongly, private respondent has been appointed and she is already now around 2 years in service.
Tell me how this appointment was.
My lord, 2 years, therefore, my lord, 2 years she has already been in service.
That is of no consideration.
So, my lord,
The appointment is void ab initio. It can be interfered at any point because the other side is a person who would have otherwise been eligible for that has been kept out.
Yes,
So
my
now
lord.
tell me, if the sports department's categorization marking is to be followed, how did the UD department, without assigning any reason, get?
My lord, therefore, my lord will see how, in fact, I'll take your lordship.
Radon, you are appearing for both.
Yes, my lord. That's why I'm in a fix, my lord. In fact, in the minutes itself at page 88, while recommending at page 89, my lord will see. Page 89. What they have decided. Board observed that before publishing result, vetting through Department of Administrative Reforms, Government of Arunachal Pradesh may be done. Till that time, results it can be kept in seal cover. Once vetted and approved by the Department of Administrative Reforms, subsequent approval may be sought from the government for appointment against the two posts of junior engineer under MSFP.
Where are you reading? 88.
Page 89, the last paragraph. This board who made this recommendation, they were also not sure. So what they have written that vetting of the administrative department or administrative reforms department has to be sought. And as for the file notings, administrative reforms department has declined to give any opinion because recommendation, they don't have any say in the recommendation. Ultimately, this was published, my lord. That is...
Lekhraj is okay, he's having an international tournament, international junior, whatever, it's international. So he's in a class apart.
Yes, my lord. My lord, therefore, to balance the interest, if, my lord, may I pray that this matter be remanded back and let the authorities take a decision whether the petitioner can also be accommodated, my lord, if that can be.
You come up with that proposal, we will give it the required push.
My lord, that I'm praying, my lord, if
because see, I can't direct, because that will be an appointment beyond the vacancies that this court is not going to do. You come up with a proposal to protect the service interest of
instruction
Mr. Panning.
My lord, that's why, my lord, I have sought instructions from the department, and
What did
they also say if my lord directs.
Why should we go to
We'll
do it in the legal manner. We will interfere with this election and say that do it afresh. And we may even go to the extent of saying now that many more candidates might have come up, go for a fresh recruitment exercise. Both goes.
My prayer will be that my lord may observe that this to reconsider the cases.
There is a number 2 in between.
Yes, my lord.
So we'll say that petitioner not entitled. Number 2 is we'll protect Lekhraj. There is no dispute with that. Others will say interfered with. If there is a requirement for an age condonation or something, the government will consider, considering that she is working for such long time and she has been litigating before this court. Beyond that, we will not say. And if you agree, if you take a decision that no, something had happened, we'll give it a quietus, we'll appoint the petitioner, nothing like that. Otherwise, I don't find any basis for the appointment.
My lord, therefore, my lord, I'm saying if my lord.
Mr. Ratan, that I understand you're bona fide. You're trying to help out. You're trying to help out both and also to protect your respondents.
Yes, my lord.
But I can't pass a illegal order.
No, my lord, I'm just, my instructions are also that if my lord directs that the petitioner.
I can't direct. It's a settled position of law that appointments beyond the advertised vacancy cannot be made.
Yes.
Then I'll have to direct for two persons, petitioner and the person who was originally at number 2.
My lord, may I interrupt? Sorry, because so as not to waste the time of this honorable court. In Annexure 11, page 104, is a letter by the number 2, Dolang John, wherein he has said he's relinquished his candidature.
Okay, fine. So we'll have to interfere with,
So far as Bamang Ampa is concerned, your lordship has already seen. He is in serial number 8.
no, if we go by that,
Yes.
then
Number
Mania goes, we remand back the matter and require them to take a call with regard to the matter. And if it is Bamangapam, it's Bamangapam. If it is you, as per there. But for that, we'll have to hold that the sports department's categorization is final. And I
Bless
don't
you.
find that it is final. So the whole thing will go. But I'm only worried about this boy, Lika Ledge. He should not be disturbed. Yes, Mr. Pani, what is your way out?
My lord, in fact, I'm no longer in a position to say anything now. The respondent number 2, the affidavit reply, I was not furnished, but I have heard that now. After hearing that, I don't know what to say. My only prayer would be, since there was no allegation of any inducement or from my side, that observation if your lordships can make.
That's an intelligent advocate's response.
Actually, I didn't go to, I didn't have that copy. I was not furnished. This is the only prayer that I can make now, my lord. In fact, I'm submitting a judgment. After what has come out now, before this honorable court, the reply to that, I can't say much. From para 23 onwards, my lord. So your lordship sees the minutes of the board meeting, there's absolutely no reasons assigned. Now, what my learned friend, learned additional advocate general is submitting, I'm not very sure. Is he saying that he's going to appoint both?
No, Mr. Ratan now is trying to protect his clients. That's all. Nothing else. He's neither with you nor with him. He is trying to give the matter a quietus. So, he is neither with you nor he is with her. He is trying to protect his own clients who have done a mistake. He understands that.
This is the only prayer, my lord, I can make now.
Okay, let me think over it.
Yes.
My lord, my lord, may I submit something?
But who is stopping you?
My lord, in this case, my lord, I am number 3 as per the
number 2 has already given.
number 2 has already relinquished before even she was appointed. The respondent number 5. Respondent number 6, on the other hand, is in serial number 8. Yes, I have already said that. Now, this is a clear case whereby direction can be given to consider my appointment instead. Because
Against whom?
against respondent number 5.
First, we'll have to set aside respondent number.
Yes, respondent number 5.
Then direct them.
What the department has been doing, the official respondents has been doing, you did file an affidavit saying that we send the AR department for vetting. AR department file an affidavit saying that we need not vet the decision. Then thereafter, a submission was made in this honorable court referring to page 72, saying that these documents were not taken into consideration. Otherwise, she would have been rightly appointed. Whereby I made objections.
Where is that?
Lordship.
Page
74.
Page 74, Lordship. Because of this, Lordship, page 74.
Or this certificate was not.
Yes. Saying that it might have been by mistake without the sports department filing an affidavit. Your Lordship will note, till that time, it was only the UD department and the AR department who had filed affidavit. It was neither here nor there.
So you want the sports department to file an affidavit?
No, no. Therefore, I had made a prayer that this.
Are you reiterating that prayer?
No, Lordship. Now,
We'll think, madam, we'll think. Let me think.
Lordship may pay particular attention to my reply, affidavit reply to the sports department, wherein they have categorically stated that in the walk-in interview, these things were not taken into account.
Actually, that's
Yes.
why you are saying. That's
Yes.
what Mr. Ratan is saying.
Otherwise, my hard work for all these 2 years will go in vain.
It might still go, but let's see how.
I don't will consider by judgment also.
In any case, it's already applied in PWD also.
Got it.
Not yet, but I don't know till now.
She's already there in service.
What are you, forester? Oh, you're doing a great service to the country.
No, Lordship, I have filed a categorical affidavit. She has also applied for sports quota JE in PWD department.
And you are doing forest, you're protecting the forest.
Lordship, it's a group C post. It is after my candidature was rejected.
You're doing human service to the. So we'll say that to protect the environment, you.
What might have happened is, Lordship.
Heard the council for the parties at length, at some length. Hearing remains inconclusive. Registry to list this matter again on Monday. Monday ki mandari kobo 7:10 for further hearing. Let me formulate my thing on Sunday.
I don't say part otherwise it might come.
Further hearing. As a part item.
Problem.
I like that.
Item number 10.
This is rare.
I'm sorry, my lord. Can it be on Wednesday? Monday, I'm
You are
quite free. Yes.
12. 12, as a part item. Huh?
Oblige.
May I please, Your Lordship, on behalf of the petitioner side, I'm just main condition of this IA regarding, not of the main case, because the main case, the earlier time, the opposite party took the time to file a affidavit in reply, and for which already took it. I just come to the main point. This is IA of the main case. Your Honor, in the starting of the filing of the WPC, this IA also complied together for taking the interim relief. Regarding, there is a, Your Honor, my lord, on very point of time, there is a bank performance guarantee already submitted.
Have you
31
revoked the guarantee?
Already.
Already revoked.
My lord, actually, DHI appeared the matter, my lord.
Huh?
DHI appeared the matter, my lord. So he's come.
Because earlier there is a contract in between the build the bridge and there's some portion of the land. I'm not talking about the main case. It is what of the my own money which already deposited in the performance bank guarantee.
Why did you file the writ petition in the first place?
Yes, yes, my lord.
Why did you file the writ petition in the first place? Because your contract was terminated.
Yes, that's true.
So if your contract is terminated, the consequence is that the bank guarantee will be revoked in terms of the earlier contract. So what is have you gone for arbitration?
Yes, sir.
Huh?
Yes.
File a section 9 application, get it done. Why are you before me?
My lord.
Before the district judge, go
Yes.
file an application under section 9. Get your protection. If the arbitration is initiated.
No, my lord, not yet.
No, he has submitted an application for arbitration.
My lord,
You have your instructions.
my lord.
My lord.
But my lord, one instruction is very clear. My lord, that amount has already been encased by the.
Already.
Yes, already in case. That's right.
There's nothing
Then
remain.
it is in safe deposit of the government. You win the case, we will give you interest.
My lord, regarding the another missed case application, IA application 14826, which filed in last week of this month. 48. Yes, my lord. Regarding this matter, I just pray this honorable my lord, regarding the some interim relief till the disposal of the main suit.
What relief you?
Whatever that they encase the performance bank guarantee, there may be some deposit as the earlier bank of the Bank of Maharashtra. So as a fixed deposit. If he won the matter case, then other issues.
Win the case, contest the arbitration for that money, take interest. They're not present. On the prayer of the learned counsel for the parties, registry to list this matter. The main case is ready for hearing. You have filed your affidavit?
Yes, ma'am.
Not ready to receive.
For
Oh,
consideration.
sorry, I'm sorry, but no, not yet.
File your affidavit.
Yes, ma'am.
Affidavit for as a heard the learned counsel for the parties. Who's up? Mr. M. Kato, learned DG doesn't come up. So and so submits that he be granted time till 24/8/2026 to file his affidavit in the matter. No further time shall be granted for filing of the affidavit. Who's up? The petitioner is granted a week's time to file his rejoinder thereafter. Registry to list this matter again on 7/9/2026. An endeavor would be made to dispose of the matter on that day.
My lord, I just humble practice. I maybe some consideration, my lord.
Both I'll dismiss. I don't want to do that for you. If I touch it, I'll dismiss it. Why should I? You go try it, young boy. If I touch it, I'll dismiss both. I don't.
Much obliged, ma'am.
Item number 12.
Because the encashment part is gone, they have already encashed.
Yes, already in case.
To the interest that you say want the money to be redeposited in that account, that is not permissible. Only thing is that if you win the case, we can put in some interest for you there. That's all. And that I can do even without an eye.
Okay. Much obliged, ma'am.
Yes.
My lord, I have gone through certain affidavits in this case. I have to be very honest to your lordship in this case. And I made a list of affidavit in opposition, reply everything. What I find, my lord, in this case, if your lordship looks into one affidavit in the case, I put a sequence of events, transitory of events as your lordship desired, this one, and all the affidavit in opposition, reply, rejoinder. Everything I made a very short. One interesting, very interesting in one affidavit, which I find. Why they are saying, well, I have to be honest to your lordship, not for my client. I have to be honest, I am assisting the court. Why they are saying de novo, de novo? Because my learned friend is saying that is not complete, incomplete, your lordship. Just recollect what he is saying yesterday, incomplete. The fact, if your lordship looks into one of the affidavit, in 2019, 6/2019, 19/6/2019 affidavit, in that affidavit, what they have stated, they admitted one thing. In principle, 2011, that is Raksha Mantri has given. That's no doubt about it. And that is respect of, yes, now 200 acres of land. Then what happened? Then this goes and there is some board of proceeding they did not state it. After that 2011, they said there's some board of proceeding. But thereafter, identification of land, which is given to the estate officer. Now, estate officer along with the deputy commissioner, they go and they identified in the year 2016 and 17. Now, your lordship has looked into the willingness certificate and everything was given, and there was an estimate which was prepared, it was sent. What I find in this way, in the affidavit, very interesting. What they are stating that it is true, 2011. It is true that there is a conveying of the meeting on 4th of August 2017, which I have shown yesterday, additional affidavit at page 606. After that, there is a board of proceeding which was conducted in 5th of August 2018. It is 598 pages. And 21, they have taken a decision where ministry has granted, MOD has sanctioned. At 21, that estimate they have sanctioned. MOD has sanctioned. Now,
no, MOD has sanctioned what?
They total 125 crores they have estimated. They have estimated. Now that's not important. Why they are saying de novo? In the affidavit, they are saying that this has been processed. Board proceeding is complete. I'll show it. Board proceeding is completed. It has been sent for signature. In the meantime, a Doklam incident has happened. India, China. That incident happened. in somewhere in September 2018. When all this board proceeding was over, they admitted, yes, 177, we have retained this one. This incident happened. Now they want additional land. Additional land for safeguard of those, because they said we have to proceed that troop. Not only that place, in some other place also we want some additional land. Now what they decided in 2018, they identified these are the places we want in addition. It is in the affidavit, I have seen. In one of the paragraph they said that 177.678 acres of land, yes. But we don't want to retain that 177.678. Out of 177.678, 110 we want to retain. And rest 67 we don't want to retain. That's their own affidavit which has been filed.
Situation if they don't want to retain.
Now 67, now what is the effect? Whether your lordship will say, no, you don't want to retain it, then return the land. That's what, return the land.
And this land is presently under the occupation of?
The occupation of, we have given the position to the state. Now, the position, the problem here is that your lordship cannot give a direction for returning of the land because it is not provided under 40. It is provided under other section, but not 40. Now, if you look into now 68, it is their own place, 100 we want to retain. But 67 we don't want to retain. I'll read that. I have read because I have to be honest to your lordship. 67 we don't. So what they do it, they said 1 second we go for a de novo process. Entire. That's why he's saying incomplete, incomplete. Lordship got the point. That's the point. 67, I'll say one closing, my lord. 67, now there may be a question of 67. Two things I will just clarify. 67, now the army cannot say that no, we don't want to retain, revert the land. They can't. Because this is now backed by one of the provision which I have shown yesterday, that military proceeding, that proceeding which is binding on them. That is Parliamentary Standing Committee is binding on them. Now there is one thing which they are saying, no, sanction was granted on 5th of August 2018. Now, if they are not denying, there is no sanction, they are saying in principle. Now they are putting up a question, why you have issued a notification in 2017? Two notification 2017, 2015. We have not granted you sanction. What made you to issue a notification prior to that? You could not have issued. This is what they are saying.
That's what I'm asking. Yes, Mr.
I have a reply on that also, my lord.
Oh, Mr. Nawab, you are just the facilitator.
Sorry. Yes, my lord.
You are not acquiring this land for yourself.
Correct, my lord.
You are acquiring this land because Mr. Doloi would want the land. Would want the land or wants the land. Now show me that Mr. Doloi to you that I want 177 acres of land in this area. Kindly have the acquisition proceedings carried out. Because he wants the land or anybody wants the land, the land has to be acquired by you only. Now, where is that predecessor to your notices under the act of the land acquisition? That's exactly what we want to establish, Mr.
But therefore, yesterday also, your lordship put me question, my lord. Your lordship may kindly parents, my lord, the additional affidavit filed by the deputy commissioner, my lord.
And also tell me, who is the authority of the Union of India? Who has to give you this request? It cannot be from a clerk somewhere. It has to be from some authority. Who is that authority? Page.
My lord, page 691. It should be the internal page, my lord.
691.
Yes, my lord. It's dated 33/2012. Your lordship got it. It's addressed to the deputy commissioner, my lord. Subject acquisition of 200 acres of land, private land at Chaklagam, my lord, Anjo district. And sir, reference has been given to all the correspondence of the armies
Your Lordship may kindly come to my Lord, serial number 3, my Lord. In this regard, a board of officers required to be convened by the LMA, that is, my Lord, local military authority, to get the sanction of the Government of India, Ministry of Defence, before initiating action under LA Act, it's old one, 1894, in order to complete the board proceeding. The foreign documents pertaining to land under consideration are required, which may be kindly be forwarded to this office.
Mr. Das, do you have the list of dates?
Yes, my Lord.
Just the list of dates.
List of dates, yes. Other side of this. Give the other side.
So Nabam, what are you trying to say? This is the document.
This is the communication made by the defense state officer to the deputy commissioner.
And then the deputy commissioner issued the notices.
Then, my Lord, the process is started, my Lord. Then your Lordship may kindly come to my page 696, my Lord. I'm showing the correspondence made by the defense state officer to the deputy commissioner, my Lord. Your Lordship got this 696.
Got it, I got it.
Yes.
Then next.
Mano, one minute. You give this also. 1 second. Affidavit in opposition, keep this also, my together.
No, I just wanted some dates, that's all.
No. Or this one. I think that affidavit is given. No, it's given, I think. Affidavit also, this is an affidavit. 2-3 things are to be cleared, my lord. The Lordship will please ask me, I want to clarify.
No, Mr. Das.
Yes.
My lord.
Now, a joint survey was carried out.
And this was the, my lord, request made by the defense state officers.
Okay,
right,
then what happened?
Then, my lord, your Lordship may kindly come to page 698.
98 years.
Yes, Mother, this is the certificate for joint survey report.
Okay, this
signed
is
by
just
all the
a preliminary thing that you are doing,
my lord,
before the accusation starts. This is not accusation.
This is the beginning, my lord.
Beginning.
Okay, yes,
then what happened?
Then, my lord, then your Lordship may kindly come to page 714. This may be relevant. This may be, my lord. I am showing the, my lord, the communication by the different state officials, my lord. It may be, my lord, internal communication, but it was given to additional deputy commissioner also, my lord.
Page 714.
714, my lord.
Acquisition of private land.
Private land measuring so and so at Thailand, my lord. And same documents were, my lord, it was required.
Then the notification is at page 716.
716 notifications. No, my lord. Before, after that, my lord, field survey, everything was completed. Then, my lord, assessment, exactly amount and all the documents so that they can go for board proceedings, my lord. That document was sought, it was provided. Your Lordship may kindly come to page 728, my lord.
No. When did you issue that notification?
Notification is 2017, my lord.
Where 20 July 2017?
Then I will bother your Lordship to kindly come to our original affidavit.
Page 99, you will see
99, yes, my lord.
of read petition. 99 of my read petition. Notification was issued. There were 3 notifications. Please see 99 first notification.
That's what I was pointing out, Mr.
99, my lord.
Mr. Navam.
Yes.
Now, till now, we are still in the board proceeding stage, right? We are still in the board proceeding stage. Because that first letter,
my lord,
has not been taken to its logical conclusion. You have done some exercises, maybe, to facilitate, to know to prepare like a tender, to prepare an estimate. You are doing the work. But direction to issue the tender or direction to issue a notification for acquisition, where is that? That is what I want.
My lord.
Here, this 27/2017 is likely to be needed.
My lord.
It is a decision taken by you. You pay.
No, my lord, is in land acquisition not like this, my lord. My lord, under
Land acquisition, if the requisitioning authority has not required you to issue the
final notification.
How can you?
My lord, final notification. Now, my lord, here, my lord. Now, entire documents were sought, including the assessment, NOC from the forest department, no objection certificate from the landowner, everything. My lord, these are the preliminary they wanted. My lord, they wanted this document for what purpose, my lord? For board proceedings, my lord.
Not for you to take a call. You.
No.
Why are you jumping the gun?
No. They wanted this document. You lord may kindly see their letters, my lord.
The documents were wanted, provided the competent authority of the Union of India takes a call that we want to go for acquisition process.
Well, suppose, my lord, all right, there is no any assessment, there is no any notification, my lord. Right, my lord. On what basis they are going to, my lord, give the land value, my lord?
I'm not on that.
No, my lord.
Mr. Nabam, I've told you that this is the doubt I have. An assessment with regard to the liability the union will have to bear for acquisition of this land is one aspect of the matter. Second aspect is, where is the decision of the Union of India requiring you, communicated to you, please proceed with the acquisition proceedings? Where is that material?
My lord, before that, just little bit small clarification, my lord. Now, my lord, if your lordship is saying, my lord, the letter communicated by the distant officer is defense state officer to the deputy commissioner.
No, we do whatever we want.
My lord.
But the original, that beginning at page 691.
691?
That is the exercise you were doing. Please come back to 691.
691. Yes, my lord.
In this regard, a board of officers is required to convene so and so to get the sanction of the Government of India before initiating action under LA Act 1894. In order to complete the board proceedings, the following documents pertaining the lands under consideration are required, which may be kindly forwarded to this office. So this is only asking you kindly give us these documents so that we can place it before the board proceedings,
my lord.
Then send it to the government to get its sanction and then proceed.
Yes, man. Agreed, my lord. Now, my lord, how this document will be, my lord, given to them? Assessment. Now, deputy commissioner duty is to...
That's what I'm telling you. If a person comes tomorrow, say, I want to set up an industry. I go before the deputy commissioner,
my lord,
saying that I want 100 acres of land. Give me these documents. Is that acquisition? Will the deputy commissioner immediately go ahead and say 40 and take over the land?
But without government approval, he can't do that.
Not government approval. Where is the requirement of the requisitioning agency? Please make the
final notification, all these things, my lord. My lord, here is the case of under section 40, my lord.
40?
40.
You come to page 99 now of the writ petition.
My lord, before that, just a minute, my lord. Now, the deputy commissioner duty is to, my lord, make the assessment, find out the owners, NOC, everything. That these things will be placed before the government for approval, my lord.
Okay.
Rates, everything, my lord.
You place it before your government.
Yes, my lord.
The deputy commissioner place it before the government of Arunachal Pradesh.
Regarding my land compensation rate, everything, my lord.
Now come to page 99.
99 of the petition, my lord.
Now, this is the notification 41, right? This is one of the notification. And here, now tell me, 1, 2, third paragraph, whereas it appears to the governor that land is needed in urgent for establishment of divorce. Now, where are you drawing this conclusion from? Because they have not said till now, acquire the land.
Right from the beginning, if it is the intent of.
Oh, I want, say I want to do something. I just ask, Arey, I want to do this. What would be the cost? What would be the area I can get? Whether the people will agree. That is a preliminary assessment stage.
Then why under 40, my lord? It could have been in different way.
Who asked you to do it in 40? Show me that. Who asked you to do it in 40?
My lord, also the communications.
Of the government of India that please get this under the urgency clause.
The urgency should
Because
have been-
I was trying to find out, but I've failed.
Please see one, I'll help your lordship. That your lordship has posed a question. 1 second. Your lordship has posed a question that where is that urgency clause? They have asked for some additional affidavit there. Please see now. Urgency clause where they have set it. Please see page 607. Have additional affidavit. Please see. This they cannot deny, it's their own thing. At page 607, the lordship is putting a very pertinent, which I try to assist your lordship at page 607P. CP. 607.
When is this meeting up?
This is 4th of August 2007 before board of proceeding, which was sent to them. 6th of August 2017.
No, this is
My lord, see, my lord.
board of proceedings.
No. These are conveying order before board of proceeding. Conveying order before board. This is 4th of August 2017. Now please see P in that 607. P. Sub please 607P. This is order 4th of August. Kindly say P, the acquisition of, lordship, see P, acquisition of so and so at various.
Mr. Das.
Yeah.
Oh,
1 second.
Mr. Dole, if you want to be there, be there. I'm trying to just understand the whole thing.
Yes.
Mr. Das, no dispute that they were contemplating. But contemplation and action are both different.
No, see, my lord.
Where is these are board proceedings
No, I know.
within the domain of the army.
Now, yes.
Within the domain of the army. From where did it get communicated?
No, your
to the
lord,
deputy
I have understood what your lordship is saying. No, your lordship is asking, I know. What your lordship is asking, that I want to see the communication from army to the deputy commissioner,
Do this.
where to do this and for invoking the clause under 40. Your lordship is asking that. Now, your lordship will kindly see, even then in a case under 40, notification is also not required.
Das, I'm saying.
Notification also not required.
That is not required.
Not required.
Here the question is, your land has been
Now
acquired.
today,
Your
yes.
land has been acquired by the government for purportedly for the army.
Yes.
Purportedly for the army.
Right.
Now the army's stand is that yes, we wanted,
Yes, correct.
we were processing.
Right.
But we had not decided to take it over,
Yeah.
acquire, because the process was still on. Now, in such circumstances, let the state pay the money to you.
No, that's true. I don't mind, my lord. That's I have to assist your lordship. Yeah, it is not.
Thus, I got it.
It is not a case.
Your land you have given up.
I have given up long back.
With the state. Now it is state land. Once that land is acquired, it becomes the government land. That is the law.
And there is no reversion of this land also.
We did not. Now we will direct Mr. Nabab to determine the amount and pay it to you. Finish.
And that is determined by state itself, 125 crores. That has been determined by the state.
125 crores. You now open up your purse. Because they don't want it. And if they tomorrow want it, you take the money from the central government.
How come they say, happy married for so many years? Now say, okay, we are divorced, we are not concerned. How come?
Unfortunately, the dispute is before the family court. What to do?
Now what we are saying, army authority, now.
Mr. Nabam, show me one document wherein they have asked you, please proceed with the acquisition proceeding. We have decided that this is the estimate that you have given. We are agreeing because, see, Mr. Nabam, you are jumping the gun again. Once you issue a notification under 40, you have to make 80% payment. You have to make 80% payment. Now, you don't have the money. You went ahead, acquired. Who is this deputy commissioner? He's alive or he is retired?
My lord,
Criminal cases have to be now instituted. How many people are being put to trouble?
Now you Lord said ask me very important question. Is there communication from the Union of India or a different state officer to initiate the land acquisition process?
Yes.
I told you 691.
691. So that is the only document.
This is not the only document.
No, that is the document you say by which you were directed to initiate the okay, let us see. 691. We again go back. 691.
I'm not bothered with this, my lord, this in principle approval.
We are not concerned.
Yes.
We are matured beyond that now. 691. Ah, 691. Yes, I got it.
691.
Okay. So you say that the section 40 notification was issued in pursuance of this.
My lord, yes.
After 4 years.
Yes, my lord. We started process once we got this communication from the state official.
Now then explain para 3.
Para 3, my lord, in this regard, a board of officers is required to be convened by the local military office to get sanction of the government of India. Minister of Defense before initiating action under LNA.
So they say.
Now, my lord, what are the documentation?
No, Mr. Nabam, I think we have heard it enough. We'll hold it now. In absence of a, that is only, they wanted to know the estimate that we intend to acquire. We want to know the estimate. Kindly give us the estimate so that the government can give its approval and then proceedings. You likely to be, what is this likely? Now that the land is gone from the petitioners, you have to be a. If you have any more document to show, Mr. Nabam, you can have your instructions. We'll have this matter again on Thursday. Mr. Das, you can join me online.
But can it be tomorrow and finish it online?
Tomorrow will not be possible.
Tomorrow? Thursday? Online.
You come online.
Online, I'll be in Ojima again. But it's okay, I'll be online. So please accommodate somewhere, Milo, I'll be online.
Monday.
Monday online.
Tuesday?
Tuesday online.
No, Wednesday.
Wednesday. Yes.
Wednesday.
I'll close the matter.
Yes.
My lord, my kindly note, my lord. Now, my lord, these
Wednesday
things, my lord,
No,
in principle, my lord, the things start not too tight.
Tuesday one again. Okay.
You show me,
Wednesday,
Mr. Nabam,
yes.
please, let us not delve into this much. You just show me on the next date that just an in principle thing will be enough. 2, that letter 691 is enough. Or there has to be a much more thing. I'm not taking it back to Gauhati. I'm finishing it here only.
If, my lord, they are saying that
11
they
or 12,
are aware of the final notifications.
I'm not.
Case, my lord?
No, we need not be. We need not be. They need not. Mr. Nabam, your final notification itself shows that it is likely to be required. So that means they had never given you that final go ahead and acquire the land for us. And why should we make them responsible? That. But the Learned Council for the
One point I have to make it clarified.
Then you Rashmi kindly see Malak 172 Malak. Just for a minute.
Oh no, Mr. Nawam.
Only one page, only one page.
Oh, 172. When Nawam says, how can I see?
Their intent was never to get permanent. It is the question for them to not.
172. Yes.
Yes, madam. Address to so and so. Requirement document for permanent acquisition of land at Takada.
Okay.
And these are the 177. They wanted permanent, man.
Just I'll take on 5 minutes only. 5 minutes. My lord, my Colonel pointed out that is board proceeding that is completed. That is not completed. And yesterday, what they have shown at the last page, that is only the statement made by army. That is only a statement.
It's not approved by the.
It is not approved. Nowhere signature is there. So board proceeding is not.
No, I'm not even on that. I only want Mr. Nawam to show me that why it was written likely to be required, or go ahead, acquire this land. These two things one issue. But the Learned Council for the parties at some length.
Next, my lord, the national security, my lord, was even priority to the my lord.
I don't think so. I think the Deputy Commissioner gave something else priority.
No, but without government.
That is for you to, that is Mr. Nawam, that is Mr. Nawam to clear.
But army has also filed their affidavit.
We'll see. Heard the party, Learned Council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on 12. 12.
Can it be Tuesday?
Tuesday, 11, yes. 11.
No, my lord, I will not.
No, 11.
I am already. He said, oh no. And any day, I never taken time. I have never taken time. I think my friends should do it. Monday, I'm not here, but I am better.
No. We'll do it at 2 p.m. virtually.
Yes. 2 p.m. I am traveling, my lord. Actually, Monday is the problem. No. Thursday, as your lordship. Thursday.
Not
Thursday at 2 o'clock, my lord.
Thursday, 2
o'clock.
You also wanted any communication from the central government.
Go ahead.
Asking for the government, urgency, that plan is required.
No. What I'm saying is the decision of the government of India approving the estimate and asking you to issue the notification. And why you went ahead and issued a notification under 40 when you did not have the money in your kitty to pay the 80%. That itself defeats the whole thing. I can understand your situation, Mr. Nawam. Mr. Nawam, I can understand your situation.
Another aspect.
Anybody in your shoes would not have been fighting till now. It's because
I'm taking your lordship 30 seconds. 30 seconds only.
I think this is the point. This head is not the new chip, it's the old chip.
Now, lighter vein. Lighter vein. One very senior law, he always said 30 seconds, not about. So, not suppose some law judges say you don't speak, then you don't have to speak sometime when the court is in your favor. This is what we learned.
Mr. Doloy, I just want to clear this starting point.
Yes.
Mr. Nawam will show that once if I find that no, these notifications were issued basing on the directions given by you, no further money to be.
Now, my lord, one thing, one problem is there, my lord. This additional affidavit from 21 when the sanction is being granted. They have not produced. No, they have not produced. Other records they have not produced. Till 21, they made it, and thereafter they have not done it.
No records. We want only Mr. Nawam's statement.
Another thing, clarify the benefit of India. Inadvertently, we have issued the notification. It was duly communicated to them. These are the circumstances we have issued them. Have they raised any objection to that or not?
That we will not impute them anything.
No,
because you said likely. They might have also said, something is happening. Why should we put our head in?
They had accepted, meaning they are
No, we can't. You show me a decision that of any court that even if the requisitioning authority had not given the final go-ahead. The government went ahead, acquired the land, now they are bound.
Yes.
Just show me a decision to that effect. Any decision. You're going back today.
I'm good. All right.